The job is the job. Everyone's back to back.
I know guys so smart about sometimes. I was a former attorney, sped habeas attorney, for discovery. I have responses, and all the responses do on the same. I've never seen it.
All rise. Good morning, please be seated. All right. We have everybody here who's supposed to be here, I assume. State, you ready?
Yes, Your Honor.
All right, there's some preliminary matters we need to take up. One thing I was concerned about was the use of the affidavit testimony. That may be a big part of this case, so I thought maybe we would talk about that ahead of time. I know the state objected to the use of Dr. Tester's affidavit and the other,
Yes, Dr. Hill, Your Honor.
Dr. Hill.
Yes, Your Honor. We have filed motions to exclude the affidavits and their respective reports to the extent that they contain what we believe is inadmissible evidence. As the board is aware, affidavits aren't a freestanding ability to get in otherwise inadmissible evidence. They still have to withstand evidentiary.
Okay. Yeah, well, just briefly, maybe we don't need to. I'm going to get into it at some point and decide one way or the other whether or not we need to talk about these things.
No, I appreciate that. So I'm Christina Matheson. I'm here on behalf of Mr. Harris. And I had filed a response over the weekend. I don't know if you were able to see that. But experts are allowed to rely on affidavit testimony and no, we're not trying to introduce inadmissible evidence. Actually, both experts relied on witnesses that were going to, well, Dr. Hill in particular is relying on witnesses that are going to come here live. And so this court will hear from them. And I've actually spoken with Crystal Starks and Felicia Hubbard, two of the witnesses that Dr. Hill relied strongly on, and asked them to sequester themselves. So they're not present in the courtroom.
They're not here now.
No, I've already asked them to leave. Actually, they are present. So I was actually going to ask this court. I talked to them earlier about leaving, and just let them know that I was going to talk to you about that. So that you could assess their credibility here in real time. Believe what they're going to say.
Let's let them stay. Let them be sequestered at this time, and we will save them for later if necessary to call.
I was just gonna let them step out. Is that okay? Is that okay? I'm sorry.
Excuse me.
If I might address, I'm sorry, were you done, counsel?
Yeah.
You're right, it's not simply hearsay. There was the subject of our motion to exclude, as referenced in our motion, and I can go page by page, as laborious a task as it would be in the affidavit, but it's not just Dr. Hill, and for instance, serving as a conduit for hearsay. It's also him opining on things that he does not have an expert basis to opine on. It's also him testifying to things that are not beyond the ken of the court, namely giving a characterization of the evidence at trial. It's wholly improper testimony for any witness, expert or not. And I can go page by page, as tedious of a task as it is, but the affidavits and accompanying report are fraught with hearsay and proper opinion testimony, and speculation, things that are beyond the scope of what I assume will be Dr. Hill's proper expertise, and his very conclusion is a legal one. I can go page by page, right? As tedious of a task as it is. If the
Well,
paper,
I don't want to get in. I want to go do it right now.
Yes.
I think we sort of need to just go with some opening statements and then sort of get into the evidence.
I agree, Your Honor. Maybe it would be best once after the actual case is closed and the parties are tendering evidence, maybe then we can have a back and forth about the admissibility of the report when the petition actually tenders it. Would the court be agreeable with that?
Well, since I don't know which you do it at the end or whether she wants to do it as main part of her case. I don't know.
Well, I was actually going to ask if we something similar. I was going to ask if maybe it would make sense if we kind of address this in written form after the hearing. I'm very used to capital context, and I know in capital proceedings we typically file very lengthy post-hearing briefs after the transcript has been prepared and all of that. And I wondered if it made sense to kind of address the admissibility of these affidavits in that context.
Okay. You can always certainly file something after we finish. I don't plan on making a ruling on this today without review of this and review of what goes on here today. So we'll just put that in the back of this, and we'll go. We'll just deal with all those issues later on.
That works for us, Your Honor. Thank you so much.
All right, that's what I needed to know. Just in the way of a preliminary matter, court reporter and I need to know who everybody is at the council table, and I would ask the attorneys if they would introduce. Let's let the state go first and tell me who you who's here?
Yes, Your Honor, my name is Michael Oldham, attorney for respondent from the Attorney General's office.
My name's Megan Hill, Your Honor, also from the Attorney General's office.
Catherine Norman, also from the Attorney General's office.
I'm sorry, would you spell your last name, please?
Norman, N-O-R.
Norman.
I'm sorry, I just didn't understand what you said. Thank you.
And just for the court reporter's information, Oldham is O-L-D-H-A-M. How does it look? Oldham, easiest way.
Okay. Who's this gentleman over here?
Hi, good morning, I'm Tom Ford, trial counsel.
All right, Ms. Basson, tell us who's at your table.
Okay, so I'm Christina Matheson. My last name is Mathieson. I'm counsel for Ricardo Harris, who's over here to my right. And then we're joined with two interpreters at council table. So this is Anna McDuffie. That's McDuffie. And Amy Peterson. It's Peterson.
That's a T or a D?
T as in
Peterson.
Tom. Peterson.
And you're not to speak out of turn, but I know so much of the issue is in the Segas case is about the certification and qualifications of the interpreters. Perhaps we could get an understanding of the qualifications and certifications of the interpreters, just so there's no question down the road about that, and get them sworn.
All right, I think that's a good idea. You want to handle it?
Well, so there are two other interpreters joining us, interpreters of record. I apologize, I don't know your names, so I'll let them introduce themselves and maybe provide their credentials. And then I know they're the folks that need to be sworn in for sure. Your Honor.
Somebody brought an oath with them today. We'll find them. And court boards always have it. Swear them all at the end. Yes, ma'am.
Yes, good morning, Your Honor. My name is Dawn, D-A-W-N, Duran, D-U-R-A-N. And my credentials are that I am RID, National Interpreter Certification Advanced, and SCL, which is Specialty Certificate Legal.
Okay, and you're here, who invited you to the party today? This is through the court, local,
Yes, sir.
not court. Also Dawn, on us to sort of take a step to get this put together. So, so you are here at the behest of the court.
Yes, Your Honor.
All right. That's-
Your Honor, Dr. Kara Kawis, K-A-R-A. Last name P like Peter, O-W-I-S. Similarly to my colleague, I have a national certification from the Registry of Interpreters for Deaf. Specialized certification in legal.
Thank you.
And you're going to just have representation by counsel that these interpreters are adequate and satisfactory to petitioner.
Yes,
Any problem with that?
there's no problem. And just, I'm gonna ask Anna and Amy to provide their background just so that, for completeness.
Good morning, Your Honor. My name is Anna McDuffie. I also hold national certifications through the National Registry of Interpreters for the Deaf, including the Specialist Certificate Legal Certificate.
Good morning, Your Honor. I'm Amy Peterson, and just as my colleagues, I am a certified deaf interpreter nationally through the same organization.
Thank you very much. Is any board dire needs to be taken care of as far as the qualifications of these people at this time? Everybody satisfied that they're the appropriate level of expertise to participate?
Yes, Your Honor. To my understanding, they're all SCL certified, so.
Thank you very much. Let me ask all of the interpreters to please stand and raise your right hand. Do you solemnly swear or affirm that you will faithfully interpret? Gosh, this is Spanish. All right. What would be the proper phrase?
American Sign Language.
American Sign Language. All right, let's start over. You solemnly swear or affirm that you will faithfully interpret from American Sign Language into English and from English into American Sign Language proceedings before this court in an accurate manner to the best of your skill and knowledge?
Yes.
Yes.
Thank you.
Yes.
It's a new one.
Okay, let me, just as a preliminary matter, I have scanned and pretty much all of the filings that have previously been made. And am generally familiar with the case. I read the Supreme Court decision in the case and have some understanding about the decisions that were made at that level. I have some of that in front of me and prepared to refer to. If there's another document that I do not have, we will ask you to, at such time as it becomes necessary to give that to me. We can make copies of that if necessary, and I can have that into my file. But I think I pretty well have a pretty good background in the why we're here today. So, I'm ready to start. Does the state want to go first? Yeah, I guess it's your burden here. So I'll let you go ahead.
Your Honor, before I go, I had just a couple of additional preliminary things.
Okay.
So one of them is we have several deaf people in the gallery as well. And so I was just going to ask if the court would mind sort of issuing an instruction that any of the signing happening at council table, that this is privileged and to the degree that they can kind of look away, so they don't, just that sign language is a visual language, and so essentially witnesses would be able to.
These would be these folks right here.
These folks here, but then there are some deaf spectators as well.
Oh,
So
I see.
was just going to ask for that instruction, just to maintain the privileged communication.
Any other spectators other than people that are in this room? Or I noticed we've got cameras, and I didn't know whether somebody.
Just a reminder, cameras should be off the table, and to the degree people's eyes can be off the table.
Mr. Camera person over here, we understand, please not to take pictures of
Yes,
conversations at the table. You understand that? Okay.
Yes.
Your Honor, I filed a Rule 22 for the cameras, and I've instructed all of the cameras to turn away.
Appreciate that very much. Thank you for doing that. Very helpful. All right. Thank you for that, Mr. Natson. Great.
That was. I appreciate that. Thank you, Your Honor. And then, as I had mentioned, I'm very used to doing this work. And capital context, and it's a little bit different. And so I kind of appreciate, especially Don's patience. Would like to put forward, if we would be willing, parties are willing to file briefs after this. I think that's the format that I'm much more used to kind of really articulate.
Okay.
You're just, if I might briefly just respond, we're perfectly agreeable to that, considering the sheer volume of information that we're talking about. If we may be committed to respond via brief after a reasonable time after the production of the transcripts after the conclusion of the hearing.
Sure.
Thank you. All right. So I can make my opening very, very brief if we're going to have written briefs. In a nutshell, what we have here is somebody who has a communication deficit, and he was at the time of the crime, he stayed around, he tried to communicate with police despite his deficit. He's trying to communicate with his attorney, and then subsequently with his appellate attorneys, and has kind of encountered communication errors that essentially sort of snowballed out of his control. And during that process, through those errors, we've seen some mistakes being made in the legal representation as well. And those were sort of compounded as his case rolled into, through trial and on into appeal. And so that's something that we're really trying to correct at this juncture. In addition, as we kind of present some of the witnesses, and I have gone through the exhibits and kind of gathered everything, there were some gaps in the trial counsel file, and so it's unclear, and I will be trying to ascertain that as we go through this hearing, whether there is some Brady material, because I was able to acquire some additional records that I did not see elsewhere in the file previously. And so I'll be pointing that out both to the state and to the court as we go through that. Thank you.
Thank you, Your Honor. Just the one thing I want to do is just to orient the court very briefly. Habeas corpus exists, this proceeding exists to raise allegations of constitutional violations in the proceedings resulting in a petitioner's conviction. What it is not, it is not an opportunity to retry the case. It is also not the ability of the habeas court to undo what the Georgia Supreme Court or what the appellate court in petitioner's direct appeal has already decided. So this is not an opportunity to retry the case, and where the Georgia Supreme Court has spoken already, this court is bound by that order. Thank you.
So the first witness that petitioner would like to call is Rico Harris. And my understanding is she sits in the middle. Do I need to switch?
Yeah, that's the way we normally do it.
Oh, okay.
Let you do that.
So Ms. Harris, can you raise your right hand? Repeat after me. Okay. I, Rico Harris, swear to tell the whole truth
Swear to tell the whole truth
and nothing but the truth.
and nothing but the truth. So help me God.
Thank you. Give me just 1 second. Any questions? While I'm kind of getting her started, Your Honor, there are some boxes behind you and Don, where I have some courtesy copies of petitioner's exhibits. So I'll be referencing things, but there's some copies there for you as well.
Is there anything I need to look at now?
I don't think so, but just, if curiosity sparks.
Okay, I've never wanted to be curious about looking at anybody's bank box, but.
You never know. You never know.
Okay.
Well, good morning, Ms. Harris. I'm gonna just start with some background questions. And these should be very, very easy for you. So how do you know, my client? He's my older brother. And how many years apart are you? 4. I'm sorry, I could not hear you. How many years? How many years apart? Oh, sorry. And what was it like growing up with a deaf sibling?
Just objection to relevance. I'm not certain the relevance this has any bearing on the constitutionality of proceedings resulting in petitioner's conviction.
Well, you're probably right, but I'm going to have a little leeway to let counsel.
And sorry to interject again, Your Honor, but I just want to make sure, is counsel or is petitioner proffering that trial counsel should have presented this testimony at the trial? Is this testimony that counsel believes should have been presented at trial? Because that does affect the admissibility of it at this hearing.
All right.
I can answer. So, Ms. Harris received a file from trial counsel, and we're going to get into that. I essentially had to recreate trial counsel's file. And she, in addition to, as a result of being Mr. Harris's sister growing up in that household, she has insight into his communication style and his communication deficits. And these are things that were relayed to Dr. Hill. So it goes directly toward the content in that affidavit. It would be something that, yes, I think would have been relevant for the jury to hear.
I'll allow some of that if I don't want to get into a long history of things, but go ahead. Let's go ahead.
We won't spend a long time in childhood, I promise.
Okay.
Well, it was different, but we're super close, so we had our own, we taught him how to lip read. We thought that would be very important. Even though his primary language is ASL. Some finger spelling was done in the household, and sometimes he would feel left out if me, my mom, and dad were talking, but I would let him know what we were saying, and he would read our lips. But if you spoke too fast, he didn't catch everything you were saying, so you would have to slow down. And then sometimes he still didn't catch everything, so I would just finger spell it and just let him know what was being said so he wouldn't feel left out.
Thank you. And did you attend your brother's trial?
Yes, I did.
Did you go every day?
Every day.
And did you interact with his trial attorney, Tom Ford?
We had a few meetings.
How many would you guess is a few?
Maybe 3.
And when you say you had a few meetings, was it you and Tom, was you, your parents and Tom, your family and your client?
Me, my parents, and Tom, and then me, my brother, and my parents.
Okay, so you had some meetings without your brother and some meetings with your brother.
Right.
Okay. And at some point, did he provide you with some materials?
Well, especially as a he, was it,
I'm sorry,
for clarification, sorry.
Did trial counsel Tom Ford provide you with some materials?
Yes, the discovery, he made a copy of it and we paid for it.
So you all paid for it, but he gave you a copy of the full discovery.
Right, he made a copy of it.
I'm gonna kind of, this is gonna be a little bit tedious, I'm gonna kind of walk through.
Just an objection is a full discovery. I believe there's no foundation for whether she received the full discovery. They just object to the form of the question, lack of foundation.
I'm sorry, I was repeating, how Lana had described it. Is that what was, how it was described to you, like when the materials were handed to you?
He made copies at Kinko's, and I met with him in a parking lot, and he gave me the copies of the discovery.
Okay, and it was your understanding that this was a.
That was the full, yeah.
Okay. So I'm gonna kind of walk through, well, before I do that, I'm gonna jump ahead of time a little bit. And I'm just gonna ask you, is this the first time that we've met or have we met before?
We've met before.
And do you remember the first time that you and I met in person?
Yes, it was during COVID.
Can you kind of describe where we met and sort of the circumstances of that?
It was at a parking lot of business, and I wanted you to have the information from this trial. And I also made notes from looking over the discovery, so I thought that would be helpful, so I gave them to you, and then we discussed that.
And what you gave me that day was that, to your knowledge, everything that you have retained from the trial.
Yes, and I received the discovery in the mail, so everything was printed out. That's how they gave it to my brother. So I thought that would be helpful because the original discovery that I received from Ford, that they were on discs and some of them weren't working properly, and I had no paperwork with that.
Okay, so you, just so to be clear, so we met in a parking lot and you gave me kind of a stack of papers.
Yes.
And so now we're gonna kind of walk through those papers. I'm just gonna ask you if they are what you remember giving to me.
Okay.
So Lon, I'm going to approach and hand you some documents marked Petitioner's Exhibit 35.
Okay.
We don't need to discuss the content of it. I just sort of want you to tell me if you recognize it and tell me what it is.
Okay.
Have you seen that, Mr. Owen?
I'm sorry,
Yes, sir, we have seen it.
All right,
Yes.
thank
may I approach
you.
this?
Yes, ma'am. You don't have to ask. You can-
These are some emails from JPEG, wrote through JPEG. I communicated with him through JPEG. Emails, it's emails, with a few conversations that we've had.
Is it fair to describe those as essentially sort of writing samples from your brother?
Yes.
Just for clarification, is this 36?
Oh, I'm sorry, here, I had to
just want to make sure that, I think I know what you're referencing, okay.
They
I
got,
have your index, so it's.
yeah, they just got adjusted on the index, and I apologize for the last
Yeah,
minute.
well,
But I put it in here, but it
Good
is,
understand.
it's 35 now. That's what it was.
The Worcester.
Yeah. Trying to make it actually easier. Consolidated. That's where, sorry, I'm sorry. We got.
Good, thank you for the clarification, yes.
Thank you. We have, try to make it quick, we have a bunch of these to go through.
Okay.
No, I'm sorry, Your Honor, was petitioner looking to admit that into evidence?
Oh, I'm sorry. So I do, what I might do is I have so many, maybe I'll just move to admit the group. Or,
Well, I do have.
You have some objections? Okay.
Indeed, I do, Your Honor.
okay, so yes, so petitioner would move to admit petitioner's exhibit 35.
Your Honor, we object on the basis that this is self-serving hearsay. This is petitioner's attempt to admit his statement through his sister. And these are also writing samples from petitioner to his sister in 2016, after his trial. I really don't understand either the relevance of this, and I believe this is also inadmissible self-serving hearsay. Regardless of whether she can identify it.
So Your Honor, we're not admitting it for the content of these statements between a brother and a sister. These were actually some samples that we ultimately gave over to Dr. Hill, who's a linguistics expert, to provide his opinion about Mr. Harris's communication style, and particularly his writing style. And being able to compare his writing style when he's not under stress versus when he's under stress when he issued the statements to police.
If it's not offered for the truth, Your Honor, then we have no objection to its submission.
Okay, all right, thank you.
I'm going, I have petitioner's exhibit 36. If you could take a look at it, again, you don't need to go through in detail, but just tell me, briefly identify it. And let me know if it's something that you recognize.
Yes, this is, yes, I do recognize it. Yes.
Let's just, if you were, since you did receive an electronic copy, if you were saving this as an electronic file, what might you call this file? How would you look at it?
Well, it's printed out, I had my brother's copy of the discovery, so it looked like this. It was just copies of the same thing.
So it's kind of like his arrest report from
Right.
So petitioner would move to admit petitioner's exhibit 36.
No objection to that, Your Honor.
All right, thank you.
So I'm going to show you petitioner's exhibit 37. Do you recognize that document?
I do.
And can you identify that? Can you tell me what that?
This was from one of his assignments in college with his sociology professor. And his assignment was to talk about his life and how he grew up and his background. And I actually checked his punctuation over because sometimes he's not clear with his words. His punctuation is some words can be missing, and he may be trying to describe something, but it's not like the average person's language. It's different. So I made sure I looked over it I proofread it to make sure he didn't have any mistakes, which he had a lot, and I made him the corrections with punctuation.
And do you remember talking to me about this when we first met?
Yes.
Kind of explaining his writing style and the tendency to make these grammatical errors in his words.
Yes.
Okay. I move to admit petitioner's exhibit 37.
Your Honor, we object expressly because at the conclusion of this document is opinion testimony from Ms. Harris that petitioner maintains his innocence, has maintained his innocence from day one. Essentially, it's allowing her to testify through the document as to something this court can't touch, which is actual innocence in this case. So to that end, we object on the basis of relevance.
Can that be removed or redacted from the document?
We can redact that, Your Honor. Yes.
Okay, well, I'll admit it in a redacted form. I don't see the relevancy. I mean, I can understand being my brother, she would have certain inclinations, but I don't think they ought to be made part of that at this admissible. That okay with you, Mr. Holden?
I'm perfectly fine if that can be redacted, yes, Your Honor. Thank you.
Let me show you what is marked as petitioner's exhibit 38 and just ask if you recognize that.
And Your Honor, sorry to interject, but maybe for the ease and efficiency, as to 38, 39, 40, 41, and 42, respondent would have no objection, as it is duplicative of evidence that respondent would be tendering to admit it.
Yes, I remember this.
Your Honor, thank you. Can we go ahead and move to admit the exhibits?
So we get 38, 39, 40, 41.
And 42 as well?
With 42 is the indictment, if I know correctly. Yes, we would have no objection to petitioner's indictment being admitted into evidence.
So I'm going to jump ahead to petitioner's exhibit 43. Take a look at that and let me know if you recognize that.
Yes, I remember. These were the notes that I took while reviewing the discovery. I wanted to be as helpful as I could, but knowing what was going on and just, to know what was going on with this case.
So to back up, you wanted to be as helpful as you could to whom?
To our family and understanding what happened.
And you said these were notes that you took on the discovery. Did you take these notes on the discovery file that you received from your brother and from Tom before trial?
Yes. Some of this that I received from Ford were viewable. So I was able to read some things, but a lot of them didn't work. So my brothers printed out discovery, and what I thought was the full discovery was included. I had him mail it to me, so I would have it. That's how I was able to go through the discovery of what was going on with the case.
And so these were notes for yourself, for your family, kind of things to talk about with Tom, concerns that you had about the case, that kind of thing.
Right. I even gave his attorney the notes just to be as helpful as I could be.
Okay, so you did give Mr. Ford a copy?
I did, yes.
So we would move to admit petitioner's exhibit 43.
Your Honor, we object to that submission. This is the witness's impression of the evidence. This is totally out of bounds.
I don't see the room. Tell me why it's admissible.
Your Honor, so essentially what I'm trying to do is recreate trial counsel's file. And the way that on the defense side that habeas typically works is that each appellate lawyer inherits the file of the attorneys that have come before. And so had we received boxes from Mr. Ford, I would have anticipated that correspondence with the family, that would have been in his file, and I would be essentially moving to admit his file in its entirety so that we would be aware of what Mr. Ford knew and didn't know as we're ascertaining his representation and let it be effective.
Your Honor, even if Mr. Ford could identify this, it still doesn't make it any less inadmissible. It's still the witness's impression of the evidence. And certainly the court doesn't need a witness's opinion on the evidence. The witness's opinion on the evidence is wholly irrelevant. It's already been found by the Georgia Supreme Court, and what's in the trial court record is what matters, not what this witness thought about the evidence.
Again, Your Honor, not admitting it. Not admitting it to determine what Ms. Harris thought, but more for the completeness of trial counsel file and to ascertain what the conversations about the case would have looked like pre-trial and during trial.
All right, let's take it one more step. What makes it important that Mr. Ford should have had that?
Ms. Harris communicates in here, there's kind of a series of questions that she has about the evidence, and she's sort of trying to understand what his defense is going to be. And so it gets.
I said Mr. Ford's going to testify at some point. I think you may want to reserve offering that until after he maybe explains its relevance to him or his possession of it or whatever. I don't know what he'd say, but let's wait. I think maybe too early for that. So I'll reserve it. That's not admitted at this point, but if you wish to admit it later after he testifies. And there may be others like that as well. I don't know.
There may be, because we really are trying to kind of recreate that file. Like I said, it's.
And if we're talking about what Mr. Ford knew or should have known or should have considered, then maybe that may be relevant. So, but I'm not saying it is or isn't, but I'm just saying let's wait till later. As it stands right now, what she's saying would have no real meaning in this case other than what Mr. Ford might say. So we'll wait on him.
I imagine we're probably going to have a similar objection to Petitioner's Exhibit 44. And I'm still going to have her
Let her identify and then we will reserve ruling that until later. question is, what is that?
Yes. She recognizes it.
Yes,
And can you tell me what that is?
the criminal process on the defense, for the, like, the job of the defense attorney, criminal defense attorney, on what you should expect, I guess, like, on what you should expect.
And were these materials that were provided to you, or were these things that you?
No, I looked them up, that wasn't clear for me. He's never been in trouble before, so I didn't know what to expect. I Googled some things.
So these were things to sort of educate yourself.
Right.
And I know we said we're trying to reserve.
The number on that?
Petitioners Exhibit 44.
And just to go ahead and put it out there, responded obviously objects on the basis of both hearsay and with the information contained, and also, again, overarchingly, relevance. Research that petitioner's sister did into the case about the legal process and her opinions on the evidence is in effect her providing legal argument and argument on the evidence to the court, which is wholly irrelevant.
I'm not allowed it in at this point, I'm just, this number 44, 43, I think was the one trial.
Yes.
Okay,
Yes.
same thing for that too.
So I'm going to show you what's been marked as Petitioner's Exhibit 45. It's very thick, so I don't suggest you go page by page, but if you can just flip through, tell me if you recognize it, and identify what it is.
Yes, this is a discovery that I received from my brother through the mail. Everything was printed out from the discovery so that he would be able to go over it.
And to the degree that you have discovery from Tom Ford as well, and on discs,
A few discs that I was able to read. Yes.
did they match what you see printed off here?
Well, some things, because some discs weren't readable.
So petitioner would move to admit number 45.
Your Honor, my understanding of this is the investigative file from the Marietta Police Department. Is that correct? Including investigative summaries and police reports, is that correct? These kinds of things are wholly inadmissible in a criminal trial for a variety of reasons. Chief among them is hearsay. We would question its admissibility in a habeas case challenging that very trial.
Other than the witness's testimony about the fact that she received those documents, I don't think the documents themselves would probably be admissible for any purpose of this court. At this point, you tell me why.
So these types of documents actually are pretty standardly admitted in habeas, although I recognize that they're not admissible in trial. And again, because they go toward trial counsel developing, whatever the defense was going to be and what their strategy and all of that, their strategy.
I think just due to the volume of that, taking it into the record is probably way overboard to allow you to comment on a particular thing that might be contained in there. And I think if there is something individually in some of the documents that you think is important for this court to have, that would be fine. But I don't think the whole file is going to be something that we ought to house and print and run off and all that stuff from here on out. So just a matter of efficiency, whatever. If there's something in there you think pertains to what the file says, the lawyer should have known and what she knew about, we'll get into that at some point.
With this court's permission, when I speak with Mr. Ford in a little bit, I know there was a lot of back and forth with the family, and he was very intentional about providing the discovery to the family as part of his communication, trying to work with his client.
Right.
And so I am admitting it for that purpose as well, I mean, in total, because he was really trying to convey something with the sheer volume to the family.
Your
I'm
Honor,
gonna put it in the same category with 43, 44, and 45. If something comes up that makes the contents of that admissible for some other purpose, that's fine, but just.
Okay.
I think I was presented for us back that this lady who was the witness was familiar with the stuff in that folder over there, and that's something for to take notice of, but as far as what is contained in that, that's, at this point, it's not been shown to be relevant, but you've got plenty of opportunity to try to make it relevant later on.
Okay, I was gonna try to get through the exhibits and then kind of go back and talk through them. So the next one is petitioner's exhibit 46. Somebody can recognize that.
Yes.
And what is it?
It's the medical examiner's report.
We would move to admit petitioner's exhibit 46.
Your Honor, because I'm not doing my job, but I'm this is irrelevant mostly because the respondent's continued position is this is the wrong foundation for this evidence. Whether she had it is a big respondent position, so what? It's how it impacted trial counsel's performance or appellate counsel's performance. So we would object on the basis of relevance.
Is there something particular to this witness that makes that relevant?
Yes, Your Honor. So when we have Mr. Ford, and I wasn't sure who to put first. I have a little bit of a chicken and egg problem. So Mr. Ford did not have a file, and so I am piecing together his file based on the documents that I have received from Ms. Harris. So I'm planning to go through a lot of these documents with Mr. Ford as well, and really to kind of comb through them in detail as if they were part of his file. But I did not.
Yeah. Maybe we'll reserve that for you and Mr. Ford to talk about.
Okay,
I'll hold off on that.
okay. And I don't know, I mean, I'll just maybe in the interest of time, kind of looking ahead at 47 through 53, and I'm wondering if the state has kind of been saying that I should go through those with Mr. Ford rather than Ms. Harris, even though I received them from Ms. Harris.
You're with the exception of 53, which is the warrant for petitioner's arrest, which is duplicative of a component of respondents anticipated in Exhibit 1 with the clerk's record and petitioner's direct appeal. Yes, our objections to those exhibits would be the same as the previous several, basically relevance and also as to a handful foundation hearsay. Yes, Your Honor.
Okay, the numbers 47, 48, 49, 50. And
51 and 52.
Yes.
I'm sorry, 52 I think is specific. So 40, 47, 48, 49, 50, and 51.
okay.
53, we have no objection to. At 52, once it's tendered, we'll have objections, but you're right, that is specific to this one.
All right, I'll let you, make a motion after Mr. Ford testifies
Okay,
about those.
thank you. So Ms. Harrison, take a look at petitioner's exhibit 52. Do you recognize that?
Did we talk about that? I'm just getting the numbers mixed up. The last batch was 47 through 51. Is that right?
So I think, and I apologize,
I was saying 52 was in that.
yeah, I was just, I updated my list. May I approach?
You don't have to ask for that. Just you can approach anytime you want to. If I can walk anywhere in the court.
I'm an appellate lawyer, I'm used to standing right.
So,
So it's an updated list. I consolidated some of those bigger.
So we're talking about
So-
exhibit, at this point, 50.
52,
Two
which
is it?
says transcript cost.
Okay, what's that got to do with it?
So essentially, well, I just was asking. if you
I
were
recognize the court reporter's name because I had to talk with her to pay for the transcript of the trial and then to receive it.
interested. So again, just the family putting the trial record back together. So we would then to admit petitioners exhibit 52.
Your Honor, I know it's equivalent, but I just have to object on relevance. I don't understand the relevance to this proceeding of a cost of transcript production.
I don't mean, that'd be probably too high.
It was definitely high for this family. So this family is having to, I'm having to reconstruct the record. And the family was having to essentially do the same thing with no legal training, and we'll kind of get into that. But it's relevant to demonstrate that the family was having to put this trial sort of together.
I'm gonna let you ask counsel about that, he testifies as to what he knew about that, he make a motion later.
Okay. So that one's reserved.
Yes, ma'am.
All right, so Ms. Harris, I want to kind of talk about some of the substance of what was in some of these documents and your interactions with Mr. Ford. So I know you mentioned you talked to him several times, maybe you had said 4 times. Sometimes just you and your family talking with Mr. Ford, and sometimes with your brother present as well.
Right, when my brother was present, it was before trial. And I remember one time being at the county jail as well, the Cobb County. Other than that, it was just me and my mom, and my father.
And when you met with him, were you going over some of this discovery? Were you how did you all talk about?
No, when we met with him, well, I met up with him in a parking lot, and my dad took me at the time to receive the copied discovery, the few discs that he did let me know that some of them wouldn't work for him, so he didn't know how it was going to work on my computer. But they didn't work on my computer either, but some of them were viewable. And there was another meeting. It was me and my mom and Mr. Ford. We met him at Olive Garden. I don't remember what we discussed. I don't recall what we discussed. But yeah, that's it.
I'm going to show you. Petitioner's exhibit 30, which for the court is part of the file that that I received from the Marietta Police Department in post-conviction. And I'm gonna ask you, I'm gonna ask you about this, so I just find. Petitions of 30, that. I'm just gonna ask, have you seen these, well, I'm gonna ask, if you can describe what you're.
There are pictures of my brother without clothing. He's wearing shorts. And then there's pictures of his hands and arms and his back and the front of him. I don't recall these pictures.
So you don't recall seeing those when you reviewed things with Mr. Ford?
Right, based on her answer, I will not exhibit. I'll not put that exhibit in the evidence.
I'm gonna, that's one I'm probably gonna talk to Mr. Ford.
Okay.
So when you met with Mr. Ford, you and your family, or even in talking with your brother, well, let me back up a little bit. You had mentioned earlier that you had done this research, the legal research on the exhibits, because you had not had any interaction with the legal system previously, is that?
Right.
Do you have any legal training?
No.
Just objection to relevance.
Okay, she said no.
So as you're reviewing all of this, and you're having these conversations, what stood out to you? What were your concerns about this case?
Just an objection as to relevance. Her concerns about the case could not be less relevant.
So she is a witness to this, proceeding to the trial. She's watching, what trial counsel is doing before and during the trial. And I'm just asking her essentially as a witness to interactions with trial counsel, what her impressions are.
And Your Honor, this is totally irrelevant as to counsel's performance. Even the testimony of another attorney as to counsel's behavior is hyper relevant for the Strickland standard. The testimony of a lay witness as to the impression of counsel's actions or inactions is wholly inadmissible.
I'm not following you, why that needs to be a part of it. She obviously has opinions about it, but I don't know that any of her opinions are part of this case. She's entitled to her opinion, but I don't know about Mr. Ford's performance or the appellate counsel or whoever it is. She's entitled to his opinion, but I don't know that.
I guess what I'm trying to go toward, Your Honor, is before we really get into even the deficient performance prong, a sort of subpart of that is that respondent would probably, or very likely, allege that there was some sort of strategy and some sort of decision making. And I'm trying to elicit what that likely would have been based on his interactions with the family. That's
The
where,
question
that's,
is, what did he do, what he didn't do? And if there's something that she thinks was left out, I think that's.
and that's where we're headed, Your Honor. That's where we're headed.
That would be totally speculative and also call for an improper legal conclusion. And also would be something that the trial counsel would be the proper witness to address.
I agree with the state. It's something, like I said, it's
Okay,
not something this court really needs to consider, or could really realistically maybe have the capacity to consider.
I'll back up. I'm not trying to, I'll back up. I'm trying to bring Ms. Harris as an actual lay witness and trying to underscore that she does not have legal training and is not coming in as an expert trying to opine about trial counsel. We're actually trying to discuss what her interactions are. But I think go about that a little bit differently.
All right,
Um,
might want to try that.
So Ms. Harris, I know that there were these conversations, there was a lot of discussion, about, Mr. Harris and some jewelry. Do you remember some of those conversations?
Yes.
Or do you remember that from trial, do you remember that being an issue at the trial?
Yes, and I remember talking to Ford about it. It was a beaded bracelet. It was an onyx with glass beads, and he wasn't wearing that. And so Ford wanted to know. He did ask me the day before trial to bring in the bracelet, and I did. But then the day of trial, he told me he didn't need it anymore, which I didn't really understand because I thought it would be helpful. So I did bring it.
So I want to back up a little bit. So when you say he wasn't wearing that, you mean there's a bracelet that was being discussed, and it's an onyx bracelet, and your brother is the he in that sentence. Your brother was not wearing that bracelet.
Right.
Is that objection to foundation? What's the basis of her knowledge that he wasn't wearing? Was she present at the scene of the Howard Johnson at the event? Otherwise, this is totally, she's saying that her brother was not wearing it during the events that led us to be here. That would make her an eyewitness to whatever happened. That's the only way she would be able to say whether he was wearing it at the time.
So
Otherwise, she's attempting to, the knowledge would only come from her brother to make this self-serving hearsay.
So there's actually, there are two beads that came into evidence at trial. One is embedded in the victim's chin and one is found on the floor of the hotel. And this was talked about with both the family and with my client, with defense counsel. Miss Harris had her brother's bracelet fully intact, which could not have been intact if it had been broken on the night of New Year's Eve.
Okay, so she's testifying that the bracelet that was on the beads, those two beads, could not have been
Could not have been the bracelet he was,
supposedly wearing on the occasion.
correct.
Okay, but is that part of an exhibit, or is that a question about the beads?
So I'm asking her, she's saying she had the intact bracelet and the trial counsel had asked her to bring the bracelet. And we kind of walked through that, but and the next thing that she said was that ultimately said, no, so it has not been.
Okay, well, I think she's testified as to that point. I think is any use of that item, no question about that particular piece of evidence, so that would be better addressed by trial counsel as to
How they would have used it, yeah. I just wanted to have her testify about that particular interaction,
Okay.
what she partook.
Right.
So, in addition to the bracelet, I know that there were also some witnesses that were called. There were three women who were called to testify against your brother. Did you know those three?
Yeah, I knew two of them.
You knew two of them.
Yes.
Who were the two that you knew?
One is the mother of my youngest niece, his youngest daughter, and an ex-girlfriend from college.
Do you remember their first names?
Melanie and Christina.
And which one is which?
Christina is the mother of my youngest niece, and Melanie was the ex-girlfriend when he attended RIT in Rochester, New York.
And did you or your family have any concerns when defense counsel told you that these three women are going to come and they're going to testify against you?
No.
Why not?
Well,
This is an objection as to relevance of their concerns. The concerns of the family about individuals testifying. I don't understand the relevance.
So we're talking about the 404B witnesses, we'll get into the relevance of those particular witnesses with trial counsel. But I think, again, this sort of goes more toward kind of communication with the family, communication with the client. There's a lot of kind of breakdown happening. And so I'm trying to pull that out.
The family's reaction to hearing that these witnesses were going to be called, I don't think is particularly relevant unless it leads to some other interaction with trial counsel or something that so
And we
far
can probably
not
get
front-
more
front
into
of
it with trial counsel. So
That'd be good.
um, Ms. Harris, when you and your family met with Mr. Ford and with your brother, did you have any concerns about whether your brother was understanding what was going on?
yes, he wanted him to plead guilty.
He being who?
Oh, I'm sorry, my brother. Or Tom Ford, his attorney, wanted my brother to plead guilty.
And so did your brother understand that that's what he wanted him to do?
This objection foundation, how would she know what her brother's understanding was?
Question.
So as you communicate with your brother, and I understand that ASL is a very visual language. Your family does a lot of lip reading. Do you sign as well?
I know a few things. Finger spelling and some ASL, yes, I do. Know a little bit.
And how important are facial expressions, visual cues, things of that nature?
Very important.
And so do you feel like when you are communicating, whether with your brother or any person that is deaf, or his friends or something, do you feel like you have a keener, or do you feel like you have a sense of whether that person is tracking what you're saying?
Just objection calls for speculation in the sense
You phrase the question. I don't know what tracking means. I don't know exactly what she knows about. We started off with the premise that Mr. Ford wanted him to plead guilty. How did she know that? When did she hear that? Did she get it from her brother? Did she get it from Mr. Ford? What? I don't know.
Okay.
So that's
Okay, yeah, we can back up, I'm sorry. So yes, I guess we can back up to how do you know Mr. Ford wanted to run?
We met with Ford and my brother, and it was me and my mom and dad. And he's, I guess, that's when it was said that he wanted him to plead guilty. To make a deal, I guess, like a guilty plea, have a guilty plea.
Mr. Ford said it outright.
Right, yes, during the meeting.
And what was the reaction to you?
Well, my brother was upset, we were upset, and we were always taught, growing up that if you did something wrong, you
There's just
Say
a objection as to what they were taught growing up. I just don't understand that allowed.
Suspending that.
So, just keeping to the, reaction that you had in that moment.
I was upset.
And I bet it's her reaction is also.
I'm sorry, your family, your brother, the reaction to council's, recommendation that your brother take.
It's the same objection there, maybe even her perception of her brother's reaction is also foundational, irrelevant. Her impression of the family's reaction is just not relevant.
I'm gonna allow the answer to the question, but again, it's the relevancy of this point.
Can you repeat the question, please?
I don't remember exactly how I phrased it, but, when Mr. Ford, recommended that your brother, plead guilty, what was the
We were very upset about that.
And did you, did Mr. Ford explain why he wanted your brother to plead guilty?
He didn't have any, defense.
Did not have defense?
Right.
Did he say that?
Yes.
If I can have just a moment. Actually, I have, just a few more questions. Did you attend any of the pretrial proceedings, anything that happened in court? before?
Yes, preliminary?
Mhm.
Yes, I attended that with my parents.
And are you aware that the prosecutor, was seeking to find defense counsel incompetent?
No,
Just an objection to this characterization of the record. I guess we'll quibble about that, but we disagree about what the record says. And so we would object to lack of foundation based on what the clerk's record shows.
Okay, I don't have the record in front of me, so I don't know what you're talking about.
Yeah, just for the court's information, petitioner's counsel is referencing the state filed a pretrial motion to determine competency of counsel. Not seeking, its respondent's position that it was not seeking to render him incompetent, but to simply ensure the court and petitioner were aware of information that might have bearing on counsel's continued ability to represent petitioner. It wasn't to declare incompetent, but just to alert everyone to the presence of a quirk that might call into question whether petitioner would want to have counsel continue to represent.
And what point, from on post-trial matters or
No, this was
trial matters?
pre-trial, Your Honor.
Yes, this was actually even before a pretrial motion.
So they filed a competency motion with who? With the trial judge?
Yes.
When was that?
The hearing was held.
I'm not dying about the date, what time in the proceeding, was that right before trial or?
It was held, I believe, at least a year.
I think it was a year.
Yeah, at least a year prior to the eventual trial in this case, sure. Yes.
Okay.
But my objection simply was to the phrasing, to disagreeing with the phrasing of counsel.
Put us back on track, yeah, I'm not sure.
Sorry for the speaking of this.
I was asking, Ms. Harris whether she was aware that that proceeding had taken place and what the content of that proceedings. It's called a motion to find, I believe it's called motion to find him incompetent.
Motion to determine competency. That's not to find him incompetent, but to determine competency.
I'm sorry.
I'm just quibbling, but that's what we're in the business of doing, unfortunately. Sorry.
Yes, I do remember that.
You do remember that?
Yes.
And, was there concern when the prosecutor brought this motion? Did your family entertain the idea of changing lawyers for your brother? Or did your brother?
There's a lot of concern because he was already paid, so now we couldn't do anything else about it. So we just told him to keep him because he's, we paid him. My parents paid him already, so. And it was too late to actually change attorneys. It would be too late.
Objection, that's speculation.
So, when you say it was too late, can you describe that a little bit differently?
Yes.
Or describe it?
Well, it was during the trial. So my parents couldn't afford to
Objection,
pay.
that's a mischaracterization of the record. This happened more than a year prior to the actual trial of the case.
Is she talking about some other time?
No, it did happen about a year before the trial, but I don't know, I don't remember if there was a trial date that was sooner if it got bumped. But, go ahead.
I remember during trial, the judge mentioned that motion and he asked, did my brother want to change attorneys during trial? So that's what I'm referring to.
Okay, you're referring to.
I'm referring to that.
You're right, you're right. There
I'm
was
referring to that.
a discussion
It
lately.
was during trial and he was
Right.
already paid and it was too late and my parents couldn't afford to get another attorney at the last
At
minute during trial, right, at that point.
Did that make sense?
A little more, yeah, yes, go ahead.
Did you or your family ever talk with defense counsel about possibly working with an expert or trying to help counsel and the court understand deaf culture in ASL?
Yes,
And what, can you describe those conversations?
with which part?
Like the recommendations maybe that you would have made or suggestions that you could say.
I remember my mother paid for an expert for I think it was for the medical examiner, and then she also paid for interpreters during meetings with my brother and Ford, so that my brother would understand what was going on. So my mom paid for interpreters to be present because no interpreters were available to assist with that, so it was paid out of my pocket for my mom.
When you guys did that, did you all, you or your parents, when you hired those interpreters, did you talk with Mr. Ford about ASL and the need for the interpreters and kind of what was going on?
Yes, we did, over the phone, yes.
Can you kind of describe what you might have, how you would have characterized the need for interpreters?
Well, Ford noticed that his communication, it was hard for me to communicate with my brother sometimes, so we told him it would be best to hire an interpreter to help out with that. Because I think they were writing notes back and forth with that like I said earlier, my brother's first language is American Sign Language, so his spelling and punctuation isn't always clear.
I think that is all that I have for now. I believe Mr. Oldham probably has some questions for me.
It's an occupational hazard, I apologize in advance. Ms. Harris, were you with your brother at all on, so you obviously weren't present at the Howard Johnson Hotel? Is that
No.
correct?
That's correct.
Your brother attended a party earlier that evening. Were you present at that party?
No.
Were you present with him at all that evening, period?
No.
So you weren't with him at all from the December 31st to January 1st, kind of the dates in question? You weren't with your brother at all, is that correct?
Right.
Your Honor, no further questions.
All right. Thank you. Anything else?
I just have one question. Where were you on that night, December 31st?
I was in Indiana. Where I was from, South Bend, Indiana.
Thank you. You can step down. Do you want to stop for lunch at this point? Maybe it's high noon right now. Want to take an hour for lunch and come back?
I would prefer that, Your Honor, because I have to go and refill the money on my part. That's important to my
Spiritual parking garage. You may want to talk to this lady right here. She may give you some suggestions about some other place to park. Yeah, we'll take it, we'll reconvene at 1 o'clock.
All rise.
Promise to bring it back.
Just
Exactly.
And we are.
Is that one?
Yes.
And you cannot just put money in the meter where your car is. Because you can only be there for
Well,
it's ridiculous.
once I realized what the street parking was 3 hours, I was like, we can't have lunch at that.
And there's two words in the corpus. Okay, there's one.
Yeah.
Really nice interview. It's not maybe true.
Yes. Apologize anytime I talk, I'm sorry.
It is on.
Well,
Your
it's-
seat is fine. She's my girl.
All rise.
Thank you for that. I'll try to be more. Sorry.
Thanks, be seated.
So Mr. Harris would call Tom Ford.
Your Honor, just right before he gets, I just wanted to let Your Honor know, I will have to, just me, obviously, the rest of everybody staying, I have to leave by about 3:30. My husband is out of town and I have to get back to Noonan to pick my toddlers up from daycare.
No problem.
Thank you. I just wanted to let you know, right, left.
Thank you, thank you.
Can you raise your right hand and repeat after me? I, Tom Ford,
I, Tom,
do solemnly swear
do solemnly swear
to tell the whole truth
to tell the whole truth
and nothing but the
and
truth.
nothing but the truth.
So,
So help me God.
So, could you please state your name and your profession?
Yes, my name is Tom Ford. I'm a criminal defense attorney here in Georgia.
And Mr. Ford, how do you know Ricardo Harris?
I have the pleasure of representing him 10, 12 years ago.
Do you remember how you came to represent him? Do you remember how you were contacted?
Don't. I don't.
That's okay. That's okay. And do you remember what county this was out of?
Colin,
And is that where you generally practice?
I practice all over the state. I've had lots of cases in Collin County and Metro London, yes.
Okay, okay. Are you familiar with the discovery process in Colorado?
Yes.
Can you kind of describe that process?
It's changed over the past quarter century that I've been practicing, and I don't recall the specifics of his case, whether it's open file or whether the discovery was provided. Many counties now put it online now. That wasn't the case then. So I believe the discovery was copied by the state and handed to me, is what I believe. I don't believe it was open file process.
Okay. I'm gonna jump right in and show you a couple of documents. Your Honor, in particular, I'm gonna show him the documents that we had kind of reserved for Mr. Ford.
Okay.
If you could just take a look at them, let me know if you recognize them and identify the substance. So I'm actually gonna start with petitioner's exhibit 45, which is marked in quotes, Marietta Police. So it's petitioner's exhibit 45, you can take a look. It's pretty lengthy, so you don't need to keep my page, but.
I assume the first part of this is his statement transcribed. Is that right?
It's one of the pretrial hearings.
Yes, ma'am.
So just in general, are these, this document, do you recognize these?
I believe I do, yeah. I mean, I've not seen, of course, this information in some time, but this is Detective Enron's notes, et cetera.
Is it fair to sort of characterize it as the discovery?
Yes.
Okay.
It is the discovery.
And did you at some point meet with Mr. Harris and with his family and convey the discovery to his family and also him?
Convey.
Did give,
Provide the same? Yes, yes. Good.
and does this look like it's likely the contents of what you?
Yes, I have no reason to disbelieve that these items were not part of the discovery handed to
Okay.
myself and ultimately handed to Mr. Harrison's family.
I can take it off your hands.
Sure.
I have a few more that I think are in the same vein. I'll just sort of ask if you recognize them as part of the general discovery. So the next one is, I'm gonna have him take a look at all of these because they're kind of similar. So the next one is Petitioner's Exhibit 46.
Yes.
You
I've
recognize
seen
that?
46, and that was handed to me by the state, and I'll provide the same to his family.
Here's Petitioner's Exhibit 47.
The same regarding 47.
And Your Honor, if we could simply have counsel identify these, I believe this was part of the big swath of exhibits that we just decided to reserve ruling to identify them. Just what
What number they are?
What 47, 48, 49, 50, and 51 are.
I can, yes, so I just handed him Petitioner's Exhibit 48, which is labeled mugshot and rap sheet Rico.
And I do recognize 48 as well, and hand the same to
And it'll feel like deja vu with number 49. So this is Petitioner's Exhibit 49. Also labeled mugshot and rap sheet Rico 2.
Yes, the same. Identify the same, and hand the same to his family.
So then Petitioner's Exhibit 51, labeled the toxicology report.
Yes, ma'am.
You recognize that
I
document?
do, and the same response. 57.
And I think that's it for the discovery. So all of those you recognize collectively as part of the discovery that you received from the state and then that you handed over to Mr. Harris and Ford's family.
Yes, ma'am.
So Your Honor, petitioner would move to admit exhibits 45, 46, 47, 48, 49, and 51.
And And Your Honor, to the extent that these are offered for the effect they had on council's behavior, we do not object. As far as the substance contained in them, we would object. But if this is just to show what council had at his disposal and what affected his decisions, we would not object to their admission.
And that
That's
is,
the way I take it. It's been admitted for.
thank you, Your Honor. So kind of keeping in that vein that you turned over discovery, I want to talk a little bit about your interaction with Mr. Harris and his family. So why did you turn over what Ms. Harris described as the full discovery? Why did you decide to do that?
Yeah, my intention was to give his family and he everything. It was the full discovery. Everything in my possession so that they could make an informed decision as to whether he was going to enter into a plea or choose to go to trial.
Okay, so it's to make an informed decision as to whether he was going to enter into a plea or go to trial.
So they could understand the number of hours that I had spoken with his mother, father on the phone, countless, exhaustive, lengthy conversations. And it was the same pattern of conversation,
Can you describe that pattern?
which was despite the fact the state maintains they have, my son could not have committed this offense. So it was important for the family to understand what the facts were. And the only way to understand the facts is to look at the file. Rather than argue with me, look at the file.
Got it. So you gave them the full file so they would have the facts.
Help me find the defense.
So you were trying to solicit help from.
We needed a defense. It had to come from him, the family, someone. It couldn't come from me.
I'm going to show you a couple of other exhibits. So for the court and for the state, I'm looking at the documents regarding co-defendants. There's kind of a lot of them, all single pages. And I think that this was part of your discovery that you turned over as well. So that's what I'm showing this to you. So these are exhibits 54 through 68.
And Your Honor, for the sake of efficiency or consolidation, if Mr. Ford can identify them as documents in his possession, then we would not object to the extent we're talking about effect on recipient, in this case counsel. But as to the content of the documents, if we're talking about admitting them for what's contained in them, we would object based on relevance because they relate to another individual, eventually a witness in this case, and have, in respondent's estimation, no bearing on the forensic question of whether there were constitutional violations in the proceedings resulting in petitioner's conviction. So I don't know what they're being offered to prove or what the petitioner's presenting them as, but that's our response.
They're being, I'm admitting them as, how they would have informed Mr. Ford's decisions as counsel and going towards the effectiveness.
They're admitted info for that limited purpose.
Okay. I can hand them to you one at a time, but there's also there's one page each, so we'll kind of maybe go through them quickly.
However you want me, if you want to have one time, I'll pull them out for you.
Okay.
Make it effective, efficient. Sure. For the record, I'm looking at exhibit 54, which of course is a copy of the indictment. And unless I state otherwise, everything that I see, what I've been handed to the family, as well as the entry of appearance, which is exhibit 55. I'll just keep these in the order. That's right, I got you. 56 appears to be, a couple on, yes, I handed 56 to the family, 57. Maybe. 57, 88. I'm not sure what 57 is. I'm not sure that was part of the original discovery. So maybe. 58 looks like something that was originally provided given to the family, as does. Call 59 Neal's plea. Part of the it would have been something I could acquire to the clerk's office. I may have provided the same to the family, but it was part of the clerk's office, same as 50, same as 60. I was aware prior to the trial of Mr. Neal's plea. And I don't recall, to be candid, whether his information, which is reflected in 61, was in the discovery or not. So, that may have been something that family or someone subsequently acquired post-conviction. Same thing with 62. I just don't know that his information was part of the file. Same response regarding 63. It may have been. I just don't recall. 64, same response. Mr. Neal's information may or may not have been part of the discovery. Same regarding 65. The court notes Mr. Neal may or may not be part of the discovery, but it was sort of part of the court's file, so it was all discovered when we knew about the substance of his plea, etc. Same response regarding 66. 67 is Mr. Neal's disposition. That was not part of the state's discovery, as was 68. Was not part of the state's discovery.
Is that new to you? Have you seen the?
Well, I was aware. I mean, I was aware he had been charged and what the convictions were. So the substance of Mr. Neal's arrest and convictions was not there. I just don't know if I had the documents in my possession.
Understood. So we would petitioner would move to admit exhibits 54 through 68.
No objection based on how they're proper.
It the limited purpose.
And how did you come to know about Mr. Neal's guilty plea?
During the course of representing Mr. Harris, I became aware of it from the prosecutor.
Okay. And you've mentioned, you said several times, that you gave the discovery file of the family to try to encourage Mr. Harris to accept a plea.
Well, it was to the intent of, there was massive confusion with the family about what his options were. Massive misunderstanding. From the time he was originally arrested up to the point he made a decision to go to trial. Massive misunderstanding.
Can you describe that a little bit? Can you
Yes.
describe, yeah.
His mother's unwilling, unyielding to listen to counsel. His mother controls what decisions he makes.
So,
His mother is a domineering, talk a lot, listen a little person.
so that became the source of.
Everything is seen through his ability to speak the same language you and I speak. Everything is seen through that person, to his detriment.
And whenever you spoke with him, did you have an interpreter? How did you handle?
Initially, when I was first hired, I did not. We got along initially prior to when he was first arrested and prior to his decision to waive the fifth and speak freely pre-autopsy with law enforcement. We were able to communicate first 30 days or so, 2 weeks or so, in such a way where he understood and his family understood what the process was. It became clear to me that our inability to speak the same language was going to be relied upon as a basis to maintain, I don't understand, I'm confused. So it became clear to me we needed someone to assist us, so we can get along, but so every time we spoke from there after we had an interpreter with us. And understanding each other wasn't a problem through an interpreter.
And
He got more time from me than almost any of the other 10,000 clients I've ever done.
how much time do you think?
Hundreds of hours. Not a few conversations, hundreds of hours. A lot of handholding at the jail. A lot of exhausted. Because of his condition, I was extraordinarily empathetic. Because of his family's insistence that he doesn't understand and he's such a good person, I was extraordinarily empathetic and engaged. And I sat this 34-year-old man in every sense of the word to make certain he understood.
And how could you tell that he understood?
Because I had a conversation with him in his tongue where it was spoken back to me. And I was as pointed and blunt and direct as I am now. I wanted to make sure he understood what the evidence was against him and what risk he was, at someone else's suggestion, engaging in. Because the person he was listening to did not know what he or she was suggesting. The person he should listen to is the higher professional who has his best interest in heart as much as the family does. But I could not pierce that logical vault. No one could tell me what the defense was. No one could tell me why we weren't resolving this by a plea. No one could tell me why and how she ended up dead.
And did you, I want to go back to the plea a little bit. What were the details of that? Did you have something actually?
And 12 years on the table, 12 years to serve. At the time, it was 8%, 9% now,
And
which to this day, I will tell you each, it was the biggest mistake of your life to choose to go to trial. I told you that then, I'm telling you that now.
and what did you think would be the biggest challenges at trial?
Aside from the dead body and the last one in the room and the video showing folks coming and going from the room and the text messages from the decedent to the pimp in the parking lot, aside from that, and the embedded glass bead in the chin, aside from that, and social media posts reflecting that he may have worn jewelry somewhere the same, aside from that, you're right, there was more. It was the decision over my objection to waive the Fifth Amendment, pre-autopsy, and want to talk to law enforcement so that he wouldn't have to sit in jail without a bond pre-indictment. And Mr. Harris, who's very bright, asked me, pressed on the issue, Mr. Ford Tom, if I'm allowed to testify at trial, you can't prohibit me from talking to law enforcement, can you? No, Mr. Harris, I can't. You're incarcerated right now, pre-indictment, and you think this is an abomination. You think if you waive the Fifth and explain things, you can go home, and I'm telling you that is not how it works. But I got tired of arguing with you and your family about this issue. So we had enough conversations about the Fourth and the Fifth Amendment and the Sixth Amendment and what risk you were accepting by waiving the Fifth Amendment to talk to law enforcement pre-autopsy. I made real sure that you were clear on that before that happened. And you chose to do it. In any language, we have to be associated with the truth. Mr. Harris's problem, in addition to the evidence against him, is he's not associated with the truth. In our line of work, what a client tells a lawyer is important. And understanding to be truthful to counsel is important. And understanding you can't, because we speak a different language, and I'm not able to pick up the natural tendencies and ability to deceive that you can with the spoken word versus the gestured word. We can't determine when someone's being dishonest, not speaking our language as well. That was his problem. And listening to the wrong adult was his problem. Respectfully.
So, Mr. Ford, I want to show you Petitioner's Exhibit 41. Do you recognize that?
Yes.
And would that have been part of your general discovery?
I'm sure it was, yes.
And there are, let me just double check. There are some pages marked with some tabs there. So on the pages marked with the tabs, can you, do you recognize that?
Right, the DNA on the bead did not match Mr. Harris.
Right.
Which is a fantastic thing when you're charged with homicide.
Yes.
If you can piece together a theory that supports that.
Were you able to come up with a theory?
No, despite my request and help for the same. We never got an explanation. Perhaps there was 2 necklaces. Perhaps there's more beads. I don't know. I've got decedent with a glass bead in her chin. I've got video with no one else but my client coming and going from the room. But I would love to have an explanation as to someone else's DNA was on that glass bead.
Do you recall a conversation with Mr. Harris's sister, Lana Harris? I believe it's either would have been right before trial.
Many, not 3, many.
Many. Was there one in particular about a bracelet?
Yes. We talked about this bracelet, we talked about all the facts exhaustively.
And
We could talk about it right now exhaustively, and we'd have the same mind-numbing, circular conversation we had then.
Can you, did she give you, or did she present a bracelet?
Yeah, I don't recall that one, I'm not saying it didn't happen, I don't recall that one way or the other. Let me just put a fine point on this. The notion that there was just one bracelet and that was a red herring, okay? We've got a busted bead in the room. We've got a bead embedded in her chin. I've got video regarding comings and goings from the room. I've got text messages to the pimp in the parking lot. To create the illusion, if there was an illusion, to create the suggestion that the wrongdoer was the pimp, as opposed to no, that John was all we had. She didn't fall on the beat by herself. To spend our time trying to create an argument that some magical mystery man with the same bead didn't make any sense to me. We've got to make someone do it. It's either another John, Mr. Neal, or Mr. Harris, or some combination therefrom. It didn't make sense to go off on a tangent about a bead that I couldn't establish whose it was.
I'm going to show you Petitioner's Exhibit 46, which is the, I'll just ask you.
Sure.
We talked about it before, that was part of the discovery.
Yes,
And can you identify that?
yes, medical examiner's report. And 46 about that first. And 46 was in the
Sorry,
discovery.
one of the interviewing the witness to repeat the last sentence, I was
Yes.
unable to hear it.
Yes, ma'am. It is the medical examiner's report from Dr. Frist, and was part of the discovery and head to the family as well. 46 was.
And are you familiar with Dr. Frist?
Yes,
And
professional speak.
did you, well, I'm gonna take just a step back, and so I feel a little bit like a non sequitur, but I promise we're gonna come back to it. Can you tell me when Mr. Harris's trial took place?
Summer of 16?
Okay,
Summer?
close,
June
so
16?
summer 15.
Summer 15.
And I know that you had said that you practice in Cobb County. Do you live in Cobb County?
I lived at the time in Roswell. I live now in Gwinnett. I've been practicing criminal law in Atlanta for 25 years and expanded my practice all over the state. That I would maintain the primary thrust of my practice within the 10, 15 metro county areas. Cobb being one of those.
So in the summer 2014, there was a little bit of a scandal in Cobb County. Were you familiar with that?
At the time it broke, I don't think it was, and as I expressed to you a couple days ago, I don't recall when the issue with Dr. Chris became public knowledge. I don't recall if it was before or after the trial. I do recall.
Just object to testimony about incidents with Dr. First. Don't know if this is potentially an improper character evidence. I'm not entirely sure what we're talking about here.
So I'm trying to get there.
Maybe my objection is too soon, Your Honor, but just a shot across the bow.
I'm just trying to lay the foundation and get it there.
I recall there being becoming public knowledge upon members of the bar that he was no longer with the medical examiner's office. And I recall it had something to do with malfeasance of funds and misappropriation. And I recall when learning of this, giving thought to whether that would be advantageous or helpful in any prior cases. Now, if I would have learned of this subsequent to his trial, I would have thought the same, evaluated the same. I just don't know when I became aware of Dr. Chris's situation.
Okay.
I don't think it was prior to his trial.
But in general, the nature of
Anytime you have anything you can ask a medical examiner about that would reflect his character and your professional judgment, you want to influence it, reference that on the jury, if you can get away with it. So, in keeping kind of with this time frame, right around the time of Mr. Harris's arrest, which was January 1st, 2013, through his trial, which was June 2015. Can you kind of, and I hate to ask such a personal question, but can you describe to us kind of what was going on with you? Sure, yeah. In January 1 of 13, I moved out of my marital home for 12 years, with 12 and 10-year-old children. And by December of 13, I guess, was divorced. So I was going through a divorce during 13 and 14. We got remarried spring of 14.
And I believe, I'm going to blank on the name, I get it wrong, but there was a pre-trial hearing.
Yes. That client you're referring to in Paulding County, Elgery Cash is her name.
Yes, that's correct.
I always have to talk to kind of put this in context. It's a little bit convoluted. Your Honor, so we had a mid-4-year-old woman in Paulding County who was present when her boyfriend was evaluating her semi-automatic gun. He looks at the same, puts the clip back in the chamber. There's nothing wrong with this gun. He drops the clip out, pulls the trigger, thinking that he had not put the shell casing, blows his brains out in front of him. Now, this 45-year-old decedent is dating her daughter. everything reflected this was an accidental shooting. She calls 911, everything reflected this was an accidental shooting. She calls 911, she reenacts the event 30 times, video and audio tape. Law enforcement notwithstanding, Dick Donovan's office in Paulding County showed him was too indicted or charged with a homicide. Fast forward on trial, the daughter has court-appointed counsel. Court-appointed counsel had already assured me, because the client didn't have any more money, court-appointed counsel assured me they were going to take care of the expert. Having an expert hired to challenge the medical expert and ballistic expert. I learned Friday before trial Monday, court-appointed counsel not done either. Ms. Cash, in custody for 8 months, and her daughter, co-defendant, in custody, pregnant, both wanted to barrel forward the trial. So we went forward to trial without the ME expert. Both were convicted. At the motion for new trial, I made the decision to do everything in my power to convince the trial court that I was ineffective. So the court sends a 13th juror to bring the trial. Because I felt this woman and her daughter were wrongfully convicted. And I felt her freedom was more important than my bar license. I maintain that decision. I testified truthfully regarding my review of the discovery or lack thereof. And I testified, make no mistake about it, we objected towards influencing the trial court to step into the 13th juror. Well, that worked. He granted a new trial. The court fired off a letter to the bar regarding my representation, which resulted in a bar complaint, which resulted in a private reprimand, I believe, by the bar, which again, I maintain was the right decision. And it was that private reprimand by the bar that was referenced in the subject matter of Mr. Evans's motion. Jesse and I had tried a murder case against each other 8, 9, 10, 12 years earlier. He didn't have any concerns about my competence. But he also knew, as effective trial counsel, that that's something he needed to get out of the way to eliminate any potential issues on appeal. So that's why I filed. Ms. Cash ultimately and her daughter were acquitted.
And thank you for recounting that. I know that that is a painful chapter for being there. In that motion, you talk a little bit about also what was going on when you testified that the cash motion for your trial that Jesse introduced. You talk a little bit about what was going on at the same time. And that time period overlaps a little bit.
Yes.
And you mentioned that, for example, your divorce was, you were asked, was it distracting? And would you describe that, your divorce and kind of what's going on, bar complaint and all of that, would it have generally been a distraction? Is that a fair characterization?
Well, let me kind of answer it this way. Anything that we have going on in our life can be a distraction, but I guess the question is, did my personal life impact my decision-making in such a way where, but for the personal issues, I would make different decisions? No. Could I have been less distracted? Yes. But I could have been very happily married and attending church and doing everything the right way, but we still would not have had a defense. And I don't know what I could have, would have, should have done differently in his case. I'm a passionate, aggressive guy, and so if you're distracted and you got things going on, you may have less patience with the family. You may but it wouldn't have changed from a legal standpoint. The analysis was the same. The defense would have been the same. I could try the case now, and I don't know what I did differently.
No, that's helpful. That's good to know. Thank you. So I'm gonna show you what has been marked as petitioner's exhibit 30. And I'm gonna put forward that these are some documents that we received in post-convictions. Have you seen this before?
I don't believe that I have. We spoke of this over the weekend. I don't believe I've seen these pictures. I may have. I don't believe that. Because I think I remember seeing pictures of you half dressed. I just don't. In fact, I can tell you definitively, I have never seen these photographs.
And when Ms. Harris testified, she mentioned that there were some DVDs or CDs.
Yeah, the state had, which was routine, had given us a bunch of DVDs, and I had probably tried to access and view some, and became frustrated with the technology. I mean, I viewed, I'd also gone to Jesse's office, because he and I spent, truthfully, a lot of time. We worked collegially with each other, and we'd had this prior murder case where we really kind of got down and dirty. And so I think he was trying to avoid that. I think he knew what was coming if we had that trial. And that's why ultimately, I mean, we didn't start at 12 years. we started on not getting voluntary time. And then by the time we were done with it, he was wanting us to go away with the 12-year offer for voluntary manslaughter. And that as a result of a lot of conversations in his office, and I would have viewed the relevant salient portions of the discovery on his computer screen as we're two lawyers going back and forth before we got into battle in 6 months or 3 months or 8 months. So we were jousting back and forth. And so I knew the discovery. I knew what was relevant. I knew where our problems were.
But even when going and looking at the discovery on his computer, these pictures are new to you.
That's correct. Yeah, the photographs that I just saw of kind of happened. I don't think I've seen this before.
Okay. Could that have been, I don't know if I'm could that have been helpful to have photos showing?
Here's the thing. I mean, if I'm arguing, if our position is that mutual combat, I didn't think we were selling from my client's communication to me mutual combat, therefore justification as a defense. So I didn't feel that the lack of defensive wounds from a man accused of smashing his face into a wall with such force to cause a glass bead embedded in their chin, or the lack thereof, to suggest it didn't happen.
I also want to talk to you about, there were 3 women who testified as for B character evidence. What were your concerns with those women? Or did you have?
The fact that they were flying across the country to walk into a courtroom and testify about bad character acts, alleged bad character acts, were my concerns. The fact that the client insisted they're not going to testify, Tom. They don't have anything bad to say, Tom. They're not coming to court, Tom. We don't have to worry about them, Tom. Which I knew to be false.
And they did ultimately come.
Of course they did. They're always coming.
Were you able to communicate with any of those 3 witnesses before they testified?
No.
Did you try? Did you
Yes.
call?
They want to speak with us.
And did you know, does the name Crystal Starks sound familiar?
It does.
And how do you recall that name? Or can you place it?
I can't. We were speaking the other day, and refresh my memory, but you'll have to help me out.
Okay. So Ms. Starks was Mr. Harris's girlfriend at the time of the crime, and then also at the time of the trial. Do you recall ever talking with Ms. Starks?
Yes. Sure.
Um,
I don't recall. I'm sure I did.
Okay. But you don't actually recall talking to her? You think you did?
can't imagine I didn't if she was his girlfriend. I mean, yeah, I had to.
But you can't recall the content of those conversations?
That's correct.
I think that is all I have.
Thank you, Robert. Good afternoon, Mr. Ford.
Good afternoon.
You're an attorney,
I am.
licensed to practice law in the state of Georgia
I was up this morning.
since at least 1996. Does that sound right?
That is correct.
I started actively practicing in November of 1997. Does that sound right?
Yes.
And I've been practicing criminal defense almost exclusively. Does that sound right?
Yes.
And at the time you represented Mr. Harris, you approximated that you had at least 15 to 20 murder trials. Does that sound right?
Yes.
And if it's 15 to 20 murder trials, how many other clients had you represented who had been charged with murder whose cases were disposed otherwise?
200.
And how many felony jury trials would you say you had to this point?
200. And the number of folks charged with murder is probably not 200. It's something under 100.
And total felony jury trials, you would ballpark approximately 200 in your career? And in all the time that you've represented clients, have you had other clients for whom you needed an interpreter of some sort?
Yes.
Whether it be Spanish,
Yes.
speaking, a language other than Spanish?
Yes.
Any other sign language clients?
No.
But fair to say, prior to representing Mr. Harris, you had experience with clients where there was a communication barrier.
Yes.
So speaking through an interpreter was not something foreign to you.
No. Sometimes it might be helpful even with English-speaking clients.
And it was petitioner's family who employed you, is that right?
Yes.
And in January of 2013, does that sound right? Directly following his arrest, pretty much?
Yes.
So you were retained?
Yes.
Yes. So petitioner wasn't indigent, correct? And he was initially arrested for concealing the death of another? That all sounds right?
Yes.
And you've already touched on this a little bit, but just to kind of put a point on this, because petitioner is deaf, his family employed a American Sign Language interpreter. Is that correct?
Yes.
Mr. Webb, does that sound?
It does.
So Mr. Webb facilitated communication between you and petitioner. Does that sound right?
Yes.
But petitioner wasn't limited to only using American Sign Language, was he?
No.
In fact, he's college educated,
Yes.
isn't he? Was almost completed with his college degree. Does that sound right?
Correct.
Was going to pursue his master's degree. Does that sound right?
He's intelligent.
So can read English, yes?
Yes.
And can type English. Can handwrite
Yes.
English? Has zero issue utilizing the English language in written form with you. Is that right?
Correct.
And you understood, when you read what he wrote, you understood what he said. Is that right?
Yes.
And you communicated with him in writing during the course of your representation. Is that right?
Yes.
Both via handwritten communication. Is that right?
Correct.
He even communicated with the victim via text messages. In this case.
Correct.
Or who he believed to be the victim.
Correct.
And communicated with law enforcement in writing in this case several times. Is that right?
Yes.
So at all times, and you've already covered this a little bit, but just to punctuate it, at all times when you communicated with petitioner, you were able to without issue. Is that right?
Yes.
At any point during the entirety of your representation of Mr. Harris, did he indicate through Mr. Webb, through another interpreter, in writing, in any of the ways you communicated, that he did not understand you?
No. Let me.
Please.
Not any more than any other English-speaking or any language-speaking citizen who's overwhelmed and intimidated by the process of being charged with a crime and all the questions and confusion and emotion that go along with that. Of course, he had all of that, but not to the extent more or less anybody else, and not to the extent he didn't understand what he was doing.
And to that end, to what any client doesn't quite understand about whatever it is, what do you do with clients in that instance?
Let me kind of go back.
Please.
Having represented literally about 10,000 folks in the past 25 years, and a certain percentage of these folks are charged with serious crimes they're going to prison for, right? There's a high number of people that I've been blessed enough to protect. The only one whose family insisted pre-indictment that he waive the Fifth Amendment so that he could talk to law enforcement. The only one that I allowed to do that I argued with about that issue was him. He wanted to speak to law enforcement over my objection. He asked me, I can testify at trial, can't I? That's my decision, isn't it? Yes, it is. Then I can talk to law enforcement, can't I? Over your objection. Yes, you can.
So this was him asking you questions?
Not, it was him insisting. He and his family insisted that he speak to law enforcement pre-autopsy, pre-indictment. They insisted. That wasn't me being creative. That wasn't me suggesting, here's an angle. Set course of action, keep your mouth shut until the discovery comes in. The worst decision you can possibly make is to waive the Fifth Amendment and start talking to law enforcement pre-autopsy.
So you're explaining all this to them?
In plain, no one can misunderstand language with as much passion and aggression and as fine a point as I can muster. I screamed it if I had to. We argued a lot. And I am certain the family can recall Tom did not want him to speak to law enforcement, but client did not want to sit in jail without a bond. And he thought if he could talk to law enforcement, he could get a bond. And I told him that's not going to happen. And we argued. I don't think I've ever had anyone so stubborn.
So there was So there was no question about whether they understood you. Their responses to you were indicative of understanding, just not agreeing.
Precisely.
And the disagreement indicated understanding.
Disagreement indicated nothing but
So there was a probable cause hearing in this case, yes? That sounds familiar? At which there was an American Sign Language interpreter, does that sound right?
it was.
At any point during that proceeding, did petitioner express to you in any manner, any form, in writing or any other method that he did not understand what was
From
going
the
on?
moment I was hired to represent him, until the time that work was returned, I never heard from him. One time, on any issue. Tom, I don't understand. Can you explain that to me in such a way? Maybe we get someone else to speak my language. Maybe you just, not one time. Not once.
And you've indicated already, but just to dig deeper in this a little bit, you indicated that the exhaustive communication that you had in this case was not just with petitioner, but also his family and his mother in specific.
The decision maker was his mother. And I couldn't tell who was more stubborn, but at the time I would have him on board to make a smart decision. There'd be a phone conversation, and we go back to drawing board. So I had to, in order to help him, I had to attempt to influence everybody, not just the one who's in jail.
So to that end, based on your conversations with petitioner's family and specifically mother, you became aware of, obviously, their involvement in the deaf community. Is that right?
Yes.
And which makes sense with her son being deaf, that makes sense.
Yes.
It became clear, obviously, that she is accustomed to advocating on her son's behalf because he is deaf. Is that correct?
That was our battle lines. And he wasn't arrested because he's deaf.
So obviously the mother is comfortable advocating for her son at any point at all during the course of your representation from your initial hire until conviction. Did petitioner's mother, an advocate for her son, ever say, my son doesn't understand what's going on?
No. And you know, in terms of mother bear advocates, I mean, he's blessed to have such a staunch defender. And
So backtracking a little bit, as opposing counsel said, there was no shortage in the way of discovery in this case, fair to say? And it seems like what you testified on direct is you had access to the state's file, both in the form of what Mr. Evans gave to you, yes?
yes,
And also what you reviewed in his office,
Yes.
is that right?
yes, we have and have a relationship where I can call him up and walk in his office and take up some time, talk about the case, talk about local portions, see whatever I wanted to see.
So here in this instance, you had, exactly like I think has been admitted, you have no shortage in the way of police reports,
Correct.
yes, GBI reports,
Correct.
witness statements,
Correct.
crime scene photographs,
Yes.
the video surveillance, guess, like the 9-camera Howard Johnson system. Is that the-
What, yeah, to the extent that it was effective, what you could see, yeah, we saw the video, I had the video.
Just hundreds and hundreds and hundreds of pages of information, is that right?
Too much, yes.
And you went through every bit of what you both obtained from the state, both in person and via disc, is that right?
Yes.
And you discussed all of this with petitioner and his family, is that right?
Yes, before and after they were in possession of the same.
And all of this is with an eye toward what any criminal defense attorney is trying to do, which is develop a theory of defense. Is that right?
One is you gotta educate your family and client on what the state's evidence is going to be, what's gonna get in front of a jury, and then how do we explain these facts in front of both citizens? Common sense stuff.
So you do your individual evaluation of the evidence in an attempt to develop a theory of defense, yes?
Yes.
And ultimately, you realize, I think what you said on direct is there were significant hurdles that you were trying to overcome to find a theory of defense, is that right?
Yes.
So you sought assistance from the family to help explain what you couldn't explain, is that right?
Yes.
And
You guys are the one telling your son to go to trial, look at this damn discovery and tell me what the defense is.
I mean, your testimony on direct was that there was no defense and it wasn't going to come from you. Is that because that you couldn't find one based on the state's evidence as it existed?
Well, I mean, if I wanted to disregard my professional obligations, I could tell a client what to testify on the road from the stand. I probably could weave something together, but that's not how you do it, you know?
So you asked the family to help because you couldn't find a theory of defense to explain away the hurdles you couldn't get
In the
over.
murder case, someone else did it, or you had to do it. It's either justifiable act or someone else did it, right? Or I did it because of provocation and action. There's only 3 options. There's only 3 options of me, right? Some other dude did it. I had to do it. I didn't mean to do it.
And in this instance, you have Ansel Neal, and Ms. James is, for lack of a better term, employer.
Yep.
Is that right?
Your
But-
Honor, the interpretation is that, can you repeat that?
I'm sorry, I'll slow
Okay.
down. You have Ansel Neal, Ms. James is, for lack of a better term, employer. Is that right?
Correct.
And I guess opposing counsel has raised the question of another John. Is Does that sound right?
Right, there seems to be, from memory, there seems to be another client had frequented the room before Mr. Harris had it. And it seems that the pimp, the employer,
Yes.
had frequented the room before our client had it after that other job.
Do you recall, to that end, maybe during Neil's examination, that you can see the John that immediately preceded
Right.
could come to the room? Is that
Right, but
right?
I don't think he goes in as a problem. And just to be candid with you, in trying to find my other dude who did it, it made sense to me that it had to be the pimp as opposed to John, because that means two people had to have seen her with a beating bed in their face as opposed to just one.
Right.
It was too attenuated.
Yeah. Based on what you described, the issue really seems to be, did Mr. Harris ever tell you that when he arrived at the room, he found Miss James with a bead in her chin?
No.
So he never at all let you know that there was a bead in her chin when he came into the room?
No.
So just very quickly about what opposing counsel addressed with you about the motion to determine competency of counsel. Mr. Evans filed this motion, and it's correct, just to kind of alert the court and kind of to your point, just kind of seal things for appeal. Is that right?
I think Jesse, having dealt with me on a prior case, understands the concept of a Trojan horse trial, right?
Yes.
And I think Jesse felt that perhaps me not disclosing that to him was my Trojan horse in this case. There's a lot of chess that goes on. We're trying to advocate to jury 12 and also create reversible error at the same time.
So you think that's why Mr. Evans filed the motion?
Absolutely.
But all this was laid to bear before the judge who eventually heard the case, the trial case, yes?
Yes.
And all this was placed on the record before petitioner and his family. Is that right?
And it was a year plus before trial. Yes.
And
To this point, and I went to great lengths to discuss the matter with Mr. Harris and his family. And not so many words to say, look, if you guys want to hire another lawyer, by all means, do so. Today, please.
And their response was?
No.
So during any of the conversations you had with the family, with petitioner, did they ever let you know about possible witnesses who could have a bearing on the outcome of the case?
No. No.
I noticed that there was some manner of pre-trial hearing in maybe a couple weeks before the actual trial of the case where you sought a continuance to maybe develop a new theory of defense based on hiring another medical expert. Does that sound at all familiar to you?
There was some kind of, for lack of a term, nonsense that had come from the family.
If I remember right there's a testimony that's already been in this case about the hiring of a medical expert. But do you remember what that theory of defense would have been based on? Any medical
Well,
expert?
I don't think I gave it consideration because it wasn't even how it's made. Whatever the theory was, it was nonsense.
So at the trial of the case, there were two proceedings interpreters, is that right?
Yes.
I believe
Much
Laura,
like today.
was that?
Much like today.
Laura, Clark, and Ann Zimmerman, do those names sound familiar?
They do.
I know you already kind of touched on this, but just to put a point on the trial component of it, at any point during the trial, did petitioner ever indicate a lack of understanding of those interpreters to you?
No.
Now, have you tried?
Again, just like today.
Yes.
He sat at the table.
Yes.
There's one interpreter speaking to him. There's another interpreter in the room conveying everything. If he had a question, he would speak to me at the table through the interpreter.
So you had an interpreter sitting with you at trial?
Yes.
So regarding character witnesses, having tried hundreds of cases, you've had the opportunity to call character witnesses over the course of your career, is that right?
Yes.
Would it be correct in assuming that it's dangerous calling character witnesses, is that fair to say?
Until,
And why is it unintelligent?
well, if you've got bad character, the client has bad character. Once you put up the deacon, who's going to testify whether they believe Johnny under oath, and the deacon gets asked about all the bad character questions that you don't want the jury to hear anyway, because you have stupidity to have the deacon talk about Johnny's good character. And in this instance, we had 3 women that were being flown from parts of the country.
And in those instances, the state actually filed its pretrial notice of intent to admit those acts, is that right?
Right.
And then you had a pretrial motion on the admissibility of that evidence, is that right?
Yeah.
And you argued for its exclusion, is that right?
And all the right arguments.
And you court ruled it admissible nonetheless,
Correct.
and then the state presented those witnesses at trial.
Yes, and I just did not see the value in having good character testimony in light of 3 women that are claiming that the guy who's accused of killing the 4th woman allegedly battered or something. I thought our focus should be on this one.
No further questions subject to petition to recross, Your Honor.
I have just a couple of questions. So my first question, I kind of want to go back to, you had mentioned that you hadn't had any other clients, death clients before.
All right, so still not a trial.
But you have had other clients who had a need for interpreters. And in those cases, how do you go about assessing what your communication needs are? How do you determine if you need interpreters? Like, do you do research? How do you do that?
If we can't communicate. If someone speaks Spanish or Cantonese, and the English is such that I'm concerned that I don't understand anything, then the family's going to have to call you up for an interpreter so we can talk.
And then kind of jumping into the trial, Mr. Oldham had talked a little bit about the dynamics and the interpreters. You mentioned that you had an interpreter at council table.
Yeah, and I'm trying to remember, as I'm watching the dynamic here today, and I do recall we had 2 interpreters. Of course, it's been a decade plus, but it seems to me we had to have had one sitting beside me at the table, and one communicating everything that was being said that would go on the record. Because if he had a question or wanted to tell me something in the presence of the jury, it had to be said through the interpreter, and that's why we had 2 there. And so there had to be an interpreter at the table.
Do you recall, because we have 2 proceeding interpreters here, so they're kind of taking turns. And I believe that that's the standard practice. Do you recall if you needed to say something to your client or he needed to say something to you? Was there a pause in the proceedings and then did the interpreter come over?
No, it would have been at the table through the other signed interpreter. What I'm getting at is, I don't believe, we didn't rely upon note writing during the trial. I've got someone that can sign in the room. That someone was going to be beside me, answering his questions or telling me what he wanted to know. There was a whole lot of objection from him because we discussed everything ad nauseum. But during any trial, things come up from the client where they don't understand something, they want to tell you something. And so the only way to do that effectively is through someone who speaks the language.
So there were moments where he would indicate
There had
something.
to have been, right? There had to have been. I mean, I can't tell you there was, but there had to have been. And we had to have interpreters sitting down beside us at the table. And there might have been a third. There may have been another, there may have been 2 that were official and someone else the family had. But I don't sign, and we can't grunt to each other in front of 12 people, and you can't write notes effectively. And I wanted him to be fully aware in real time of everything said and know in real time everything. I was still hopeful he'd change his mind
And
during the
being,
trial.
yeah, and being hopeful even in mid-trial, that he's
I
gonna.
was hopeful he would change his mind mid-trial.
And, why, just why were you hopeful?
This was a long plea. He had no chance of winning. Circumstantial evidence case, sure. And you can do the nonsense and make the state go to the brick, but you gotta have for a circumstantial evidence case, for you to get an acquittal, you have to have a plausible, reasonable theory to weigh against the states. In this instance, what I'm selling is, it was the pimp. But his statements to law enforcement that he insisted upon making, in which he enters a room, they have a chit chat or flipping channels, his insistence upon how she must have passed was not consistent with the medical testimony. His insistence to talk to law enforcement really handcuffed counsel on what you can do.
And so I wanted to ask about that. So did you have a sense of why he wanted to talk? Did he convey that to you?
No, I still to this day don't understand. Other than just the shield and the sword of the deafness. I can hide behind the shield of my condition. I can use it as a sword to deceive when I choose. And I'll get behind the shield again.
But you really didn't know. I mean, I think
didn't
that's what it was.
I didn't understand that then, the way I do now.
And then I think my last question is, we had talked a little bit about Crystal Starks, and I think Mr. Oldham had asked if family suggests that you talk with anybody, I'm paraphrasing. But did they make any suggestions of people that maybe you talked to and you said, well, even if you get the bishop, this has been.
Whoever the family,
Well, do you remember them saying, do you remember them offering?
let me put it this way. His mother is such a force of nature. Anything that she would want me to do, I was obligated to do because of her personality. And if she wanted me to talk to the stars, I would talk to the stars. I pursued every rabbit down every hole she wanted to chase. And then I came back to family and said, quit hunting dead rats. Let's resolve this case. And I wish the family had listened to me. We'd be looking at 12 more months in custody right now.
I think I have no further questions.
Nothing from responding, Your Honor.
All right. So you may sit down. Can the witness be accused? Or you wish to?
We have another witness, but she was going to join us over Zoom. So I wonder if it makes sense to take a little bit of break while we're trying to set that up.
We can do that. I just want to release Mr. Ford.
Oh, yes.
If you want, so you're not going to need him any further.
I don't think so.
All right, thank you very much. We'll take a few minutes recess, just notify me when you get ready to go. And
All rise.
Thank you so much for coming.
Please be seated. Thank you.
Here, closer to it.
Okay.
Thank you for your patience, Your Honor.
It's all right. Sorry, it took a little longer than we thought.
All right, Ashley, so I've been doing the oath, so if you would raise your right hand.
Yes.
And you froze, so just tell me if your hand, oh, there you go, okay, got it. And then if you could just repeat after me. I, Ashley Merchant,
I, Ashley Merchant,
do solemnly swear
do solemnly swear
to tell the whole truth
to tell the whole truth
and nothing but the truth,
and nothing but the truth,
so help me God.
so help me God.
All right, so I'm gonna just start with a little bit of background information. How do you know Ricardo Harris?
I was appointed to represent him on direct appeal out of his conviction from Cobb County, Georgia.
And do you have an idea of when you were appointed? The time frame?
It was after he was convicted. Normally it's within a few weeks after conviction. I don't know the exact date of his conviction, but it's normally within a few weeks after that.
And are you familiar with Cobb County?
Yes, very much. Sitting here now.
So I'm going to actually ask you some questions about the trial process and pretrial a little bit, and then we'll get more into the appeals. So are you familiar with how discovery generally works in Cobb County?
Yes.
Could you describe that for us?
Yeah, so we normally file what's called an opt-in. It's a notice that we've opted into the discovery statute. We have reciprocal discovery in Georgia. So as the defense, if we opt in, the state then engages in reciprocal discovery, meaning that they give us a copy of everything that they've got. And then we have a duty to give them copies of what we have. And it's an ongoing duty, an ongoing process.
And so how does that typically work when they, like when you exchange material?
Yeah, so what they do in Cobb County is they usually put it on a disc, and they'll do initial discovery. So the initial discovery is usually the indictment, a preliminary police report. Sometimes if there's a homicide, sometimes we'll have an MA's report in that. But just, initial witness statements and things like that. They've gotten better about giving us more initially, but it used to be that you got a very limited initial pack and then you would get supplemental discovery as the case moved on. But they give us the police reports, and they get them. There's an electronic system where they're able to access, the DA's office is able to access the police department's files. Most of the local agencies, their files electronically, and they download them and put them on discs and give them to the defense.
And does the defense need to ask for those police reports, or is it just sort of understood that they'll give you those discs?
They usually give us the police reports. Sometimes there will be things that I find in discovery that aren't part of it, and so I'll regularly have to ask for those things. Like in a police report, maybe I'll just give you an example of a trial I'm getting ready for next week. There were some emails that are referenced in a supplemental report, and the officer said those emails are in evidence. We don't have them. I had to call the DA and say, hey, on page 97, there's emails, give me those. And they're like, oh, I never even knew we had those. So they're going to the detective to get them and give them back, give them to me.
So in a situation like that, is it relatively easy for things to fall through the cracks?
Oh, very easy. Like you have to go through everything to make sure because, especially when it's a large file, and there's a lot of different things. And, the DA has to know to ask for the stuff or know to go get it. So it's not like where the detective just brings everything. It's more of the DA asking for it and then giving it to us. So if it's something out of the ordinary, they may not know to ask for it.
And in this case, did you have access to the discovery? Did you?
Yes.
Okay.
I had trial counsel's file, so whatever trial counsel got in discovery is what I would have gotten. Sometimes there will be things that I will notice in discovery, or I will notice in a file that maybe aren't in trial counsel's file, and so a piece of discovery that maybe isn't there that I think should be there, and I will then have to reach out to the state to get that. I don't recall that happening in this case, but I do that regularly.
Do you recall getting trial counsel's file in this case?
Yes, I think it was Tom Ford in this case. I believe it was trial counsel. Yes.
Yeah, Tom Ford was the trial attorney. Did he give you like a series of discs, or do you recall?
I don't recall. Typically, it's electronic. There are some attorneys that give us large files. I tend to remember those because there's a room that we have those, and I see those names regularly. So the majority just give it on a disc or a CD or something like that.
And when you got the discovery, we've kind of gone through the discovery a little bit earlier today. So I've got some discovery materials that I received in post-conviction. So it's Petitioner's Exhibit 30. I think I've shown it to some of the other witnesses. I'm not sure how best to do this with you. So I'm going to try this. If it doesn't work, then I will try emailing this file to you. So I don't know the best.
I can see
How
it.
about, can you see it?
Definitely. Yeah, it looks like a photo of Mr. Harris.
Yes. And so I have a couple. I don't know if you can tell what this one is.
Yes. Yes, those were photos that the police took after the incident.
Yeah. So are you familiar with these? Have you seen these before?
I have.
Okay.
I remember them, yes.
And then I kind of want to jump forward again to your interactions with Mr. Harris. Have you ever represented a deaf client prior to Mr. Harris, prior to representing him?
I represented one client back when I was at the public defender's office that was deaf, but it was a pretrial and we were able to write. He was partially deaf, and we talked about that a little bit. He wasn't to the extent that Mr. Harris was, but that's the only client I've ever had. I definitely never had any intensive hearings or trials or anything like that with a deaf client. This was a simple felony, and we were able to write back and forth. And he ended up taking a plea. It wasn't a very involved case at all.
And how did you feel your communication was with Mr. Harris as compared to this other client?
Definitely restricted. I mean, I do like to communicate in writing, but it's hard when you're talking about facts of the case with a client. If you want them to communicate with you, they have to trust you, and so you have to talk to them in person. And so that was definitely difficult because we had to have an interpreter. I don't ever enjoy having interpreters, no matter what the case is. It's just always difficult for various reasons. I talk fast. That's one of the reasons. But beyond that, I always have a concern about translations, and I'm not saying there's anything wrong with the translator. It's just I've learned from different languages, dialects are different, and so sometimes a translator will use slang, and I'm one of those people, I want my words transcribed exactly, right? I don't want them summarized, I don't want them, any slang or anything like that, so that sometimes concerns me. And I don't have enough experience with sign language to know if that even happens with sign language.
And when you talk about it being a little bit difficult, and I understand like you wanting it to be, your exact translation, were there other difficulties that you encountered?
I can't just pick up the phone and, call him, but I have a lot of difficulties with clients that are in prison. So, it's hard for me to separate out clients in prison versus any other client. It's always easier to do my job if I can just call up a client where they can come in and we can talk. Anytime I have to go through prison system, local jail or something, there's going to be a lot of impediments. There's definitely more when you have a translation or language barrier or something like Mr. Harris. Even more, it's not even just translation, but definitely a lot more problems. I would have to have someone communicate. I mean, there's a system where we would set up a phone call and someone would have to translate for him. So it's definitely much more difficult.
And did you also communicate with Mr. Harris's family?
Yes.
How would you characterize your interaction with his family?
It was not extensive. I don't think it was very extensive. I mean, interaction with clients' family is always somewhat difficult, especially on appeal, because the appellate process is foreign to most people, so it's always difficult to explain it when there aren't language barriers. But it's like a game of telephone, especially when there's a loved one in custody, and I'm telling the person outside something and telling the person inside something, and it's a game of telephone a lot of times. So those are inherent difficulties all the time.
Do you think it would have been helpful to have consulted with somebody who knows linguistics, who could have explained maybe dialects of American Sign Language, or could have assisted in helping to retain interpreters, things along those lines?
Objection calls for speculation.
Would it have been helpful to have an expert assistance in this case?
Again, object on the basis of speculation. Would it have been helpful?
No, I think overall, she's talking in generalities and not specifics. It's okay.
Okay. So I may answer, Judge? Okay.
Sure, yeah.
Thank you. I think it's always helpful. The more help I can have, the better. So I definitely would agree that it's helpful to have more. And since I have very limited experience with people with hearing loss, that would definitely have helped me alert me to any issues unique to this case.
Did you visit with Mr. Harris in person, or was it all through the phone?
I don't remember if we visited in person. I have no reason to dispute his memory on that. I don't have any independent memory on that. I know we communicate by phone often, and that was actually easier because of I can't remember the name of the line, but there was there's some telephone system where you call in and you have an interpreter. So if I visited him in prison, I would have to actually arrange for an interpreter. For the phone calls, he sort of handled all of that through whatever the telephone system is. So I believe that the majority of our communications was either in writing or on the phone.
Yeah, I think it's called the Purple Relay System, something like that. Yeah.
Yes.
Yeah.
Relay system, yes.
Did you ever talk with, in addition to his family, did you ever talk with Crystal Starks? Does that name sound familiar?
I think that was maybe a girlfriend. It does sound familiar. I don't have any independent memory of speaking with her. If she may have been the girlfriend that I talked to, I'm not positive.
And did you ever talk with Tom Ford about his representation and his impressions?
Yes, I definitely talked to Tom Ford. I do remember that. And that's difficult. And also not visiting someone who's in prison in person is not something I would normally need to do. The one thing that prison is really good at is setting up phone calls. So, I do rely on phone calls because they're privileged and I am able to talk with them fairly easily. So I do rely on phone calls and letters for appellate purposes.
Yeah. So when you spoke with Mr. Ford, just give us a second. When you spoke with Mr. Ford, can you describe your interaction with him or his your interactions with him?
I mean, I know Tom, so and we're both lawyers in the community, so it's not abnormal for us to talk. And I've actually done a couple, 2 or 3 of his appeals or habeases that he had done the appeal. Some process like that. So I know Tom. But we talked about the case, talked about the file. One of the things that we talked a lot about was the stipulation, and the statements. There were a lot of issues with the statements. His defense of the case, his theory of the case. what he thinks happened, I always ask trial counsel if there's any issues that they remember, that they want to point out to me, anything that they wanted to follow up on that maybe they didn't follow up on, that's another area I always ask about.
And did anything stand out to him? Did he highlight anything for you?
Not that I remember. I mean, if there was something that he would have highlighted, I would have followed up on it, or it would be something that I would have put in our motion and brief.
And what did you think were like the primary issues? Like, what really stood out to you about this case?
Well, I mean, I reviewed everything, and I know that there were a couple things that I outlined in the appeal. I have a process, and I followed it in this case. I issue spot, so I go through everything, and I make a sort of a digest of everything, and then I issue spot if I think it's something that warrants merit to look at. So those issues, then, I make a digest, and so it's got the page numbers, it's got the content of the transcript, and then it's got on the other side, it's got my notes. And, if there was an objection made or not an objection made, and so I'll go through and track whatever those are, and I'll look at the case law, while I'm looking at those issues. And if there's case law that supports it, it's something that will end up in the amended motion. If there isn't, then it won't. And that's just sort of my process, and I followed that in this case. It's been a while, so I can't say I remember specifically all of the issues that I analyzed in this case, because unfortunately it has been a while, but I followed that same process.
And were you, what was your reaction to, Jesse Evans had done something a little bit unorthodox in this case, where he presented at a preliminary hearing questions as to Tom Ford's efficacy as a lawyer, and kind of brought in this other motion for new trial transcript. I don't know if you remember, if that's jogging your memory at all.
No, I do. I remember that. And that was an unfortunate situation that we were dealing with in this area at the time. Tom had a case, I believe, in Paulding County, where some of his methods and some of his lifestyle choices had been questioned, whether or not they affected his ability to try cases. And so some of the local lawyers, like Mr. Evans, were raising that just to make sure that he was okay, that he wasn't using anything, and that everything, he was focused and able to go forward. It's definitely not usual, not the only time I've ever seen something like that happen, but we were all aware of what was going on with this report, so it wasn't Mr. Evans just trying to be ugly. I don't know how to say it. It wasn't like it was just out of left field. I mean, he had a factual basis for doing that.
And can you describe that a little bit, like what that factual basis was?
Yes.
With reputation wise, yeah.
Yeah, definitely. And, I'm a lawyer in the community, so I was not part of that case. But there was a case in Paulding County where Mr. Ford had been trying it, and I believe he testified on the stand, and I would refer to the transcript, but I believe he testified that he had used drugs, cocaine specifically, during the pendency of that case, at breaks maybe over a weekend, and it was a homicide case, and he thought that drug use affected his ability in that case. So once word got out about that, there was a big issue whether or not he was using currently, whether or not he was going to be using during trial, and how that affected his ability to defend clients. And so that was what Mr. Evans just wanted to look into, just to make sure, just to really put on the record that Tom wasn't using, and that that wasn't a pattern that was likely to be repeated. Just to make sure that Tom was doing his job and was confident. Really, it was kind of a competency hearing almost, a lawyer's competency hearing almost.
Yeah. We were talking about the name earlier, so yeah. And how did when you saw that and you kind of know what Tom's going through, how did you handle that or address that in the motion for new trial or the direct appeal or both?
I talked to Tom, and the thing about Tom is he's very honest about his problems. And so, he had been very honest in the Paulding County case about it, and I think he was honest with me and honest with the court in this case. And the thing with Tom is he's actually, when he's not, conflicted with something going on in his life, he's a really good lawyer. So, it's hard for me as an appellate lawyer, I read a lot of transcripts where lawyers that are completely sober and have nothing conflicting them, and they do an awful job. Tom was actually a good lawyer. So, it was hard because I'm looking at the transcript to see, did he do a good job? Did it look like there was something that he missed because of drug or alcohol abuse, because of something going on in his life, other things with his family? I talked to him about the case. There was nothing to indicate to me that that was a problem during this trial.
Would it have been relevant that a lot of this trial happened at the kind of in the same time frame as the cash trial, or the
It was, and that's one of the reasons that it came out. That's one of the reasons that the judge had a hearing. That's one of the reasons that we all talked about it, and I had Tom testify. And I talked to Tom about it as well. And I know Tom, so we're not close personal friends or anything, but we're fellow lawyers in the community. And like I said, I have done some of other cases that he had worked on that maybe he had tried, and so I felt comfortable enough talking to him about it. He's not the only lawyer that I've ever known that had some type of substance abuse that had affected their practice. He did not indicate to me that he was using during this trial. He may testify differently about that now, but that's what he told me, and I had to believe what he told me, so.
Did any of, as you were kind of reviewing the transcript, did any of Tom's cross-examination stand out? Any of his arguments or anything like that? Is there anything that you remember that really kind of stood out?
I thought the stipulation, it was kind of the stipulation with Mr. Evans, that whole thing, but I also know Mr. Evans very well. So when I looked at that was sort of surprising. There was a stipulation with the Jackson Deno, but that typically is trial strategy. I have done that in cases before. So I had to believe that Tom had a trial strategy reason for that stipulation. I know Mr. Evans very well, and I've had a lot of appeals with Mr. Evans, so, the parameters of that agreement not being completely honored did not completely surprise me. Tom should have done a better job of getting it narrowed down, but I don't know that he had that type of experience with Mr. Evans to know that he needed a QQ event.
So Tom actually testified a little bit earlier today, and he told us that he really struggled, and essentially, I'm going to paraphrase, but he said that he had no defense.
Had no defense. Right.
Yeah. Do you recall, did he say similar things to you?
Yes.
And do you think that trying to think how to say this just right.
It could have affected his performance. I don't know. I don't know. You have to take what Tom says as, what his memory is probably better. My memory is always better when I try the case, because you're just in court more and you get more intimately familiar than reading a cold transcript. But Tom was struggling with the defense. I know that. Tom was struggling with some of the facts of the case that were hard for him to get around. Some of the alleged brutality of the case, the priors. I don't know that he felt super strong about his defense or super strong about the case. He didn't indicate that to me at least. I don't think he felt very strong about his defense.
If you had evidence, or if you had read evidence in the trial that countered or called into question some of the prior bad acts,
Yes.
the credibility of it, would that have been helpful to you? Or helpful?
Objection as to speculation. This is actually speculation. If you had read something, would it have affected? This is total speculation, Your Honor.
I'm trying to think, what sort of information would that be that you're referring to that he made?
So, okay, so I can get into the specifics. So we have a witness who is an eyewitness to some behavior that one of the women who testified about the prior bad acts, that she engaged in self-harm. and then would.
Did you say self-harm? I'm sorry.
Self-harm, yes.
Okay.
And that she would then call the police and she would try to pin those bruises on Mr. Harris. Ultimately, there are no charges. I think, as you are aware, Mr. Harris actually has no criminal history. And so what I'm asking is if, when you were reviewing the transcript and you're kind of putting the appeal together, would seeing that kind of testimony in the record, would that have been something that you would have been able to use in the appeal?
Just objection to speculation, also as the foundation, also about her ever being informed of any of this. It just calls for speculation. There's a lack of foundation for it, and also the only reason it exists in the record is that counsel is testifying.
Yeah, I think it might be helpful to let the witness explain those things that she knows. If she doesn't know anything about those things, then she doesn't know it. But I think it needs to come from her, not from you. Does that make sense?
Yes, yeah. So, so let me put it this way. Because we will be presenting this, but unfortunately you don't have the opportunity to see that witness. We have, let's see.
Well, I think the question talks about dealt with what on appeal she would have thought to be a good thing to put in there, or did she, or not, or what did she know? And I don't recall seeing. I've looked through all this. I don't remember an incident specified the self-harm and all that in any of this. So I don't know whether it ever came up in the trial or not.
It didn't, and so that's what we're talking. That's what I'm asking her.
Well, ask her what she knew about it.
Okay, so in talking with, I think I'd asked you if you knew Crystal Starks, and you mentioned that you recognized that was Mr. Harris's girlfriend. Do you recall having any conversations with her?
I'd have to check my notes. I mean, I keep notes on stuff like that, so I would have to check if I had any. I don't recall any, but that's not indicative of whether or not I had a conversation with her. I don't have a specific memory of a conversation with her, but that doesn't mean I did not have one.
Would it have been typical for you to talk with a client's girlfriend, or do you typically just talk with the client directly? How do you?
Oh no, I talk to their girlfriends all the time, which is one of the reasons I can't remember specifically. And that is a difficult aspect of my job because some of my clients have multiple girlfriends, so I have to keep lists of which ones I'm allowed to talk to, which ones I'm not. I recognize her name, so she was approved, but I don't have any specific memory. If she called my office, I would call her back. I'm very open. If it's public record, I'll talk to people about it. I don't like to not return phone calls and stuff, so I know I've talked to her. I just don't have a specific memory of talking with her.
Okay. And to be clear, if she gave you additional evidence, would there have been a way for you to introduce that in direct appeal, or?
Yeah, definitely. So if she had, and I can look and see if I have any memos with her. I mean, I think I would have given them to you all. But if she had something that I thought was helpful, that I needed to put on the stand, I would put her up at the motion for new trial phase. I do that all the time. Put witnesses up, even if it's just for one or two questions. So, if I had talked to her before we have the motion for new trial, I could have called her. Now, after the motion for new trial, I can't. Once that's ship has sailed, that ship has sailed. And so I can't introduce anything in the Supreme Court, but I can when it's still at the trial court.
It's still pending at motion for trial.
Yes.
And similarly, do you recognize the name Manisha McIlwain?
No, I don't recognize that name.
She also went by nickname Me, N-E-E.
What was it? What's the nickname?
Me, N-E-E.
Me? I might have talked to her. I don't recall her name specifically, but that, if she had called, I would have talked to her. I mean, if they told me something significant that I thought was going to help the case, I would have definitely written it down. The majority of calls with girlfriends are just, hey, why is it taking so long? Or something happened, or, just can I get a copy of this, something like that. I don't usually take extensive notes of that. But I will say, we actually log all of our calls electronically. So I can look up any number from anybody and see if they've ever called me. And then I always keep an electronic record of calling them back. So I do have that capability. People use different names, but I'm happy to look that up.
And then I think I have one more name for you. Well, I guess maybe two more. Did you ever speak with Mr. Harris's sister, Lana Harris?
Yes, I did. I remember her name.
Okay.
And I don't remember if, maybe email. When I say speak, I want to make sure I'm clear. To me, speaking is communicating. So in these days and ages, it may be texting, it may be an email, maybe something like that. So I definitely communicated with her. I'm not sure how exactly, but I know I communicated with her.
Okay.
It may have been as simple as her calling and saying, my brother needs to talk to you, and my paralegal calling her back and saying, I'm going to set up a call. To me, that's a communication. So, when I say we communicated, we did communicate with her.
Okay. But you definitely recognize the name, you just don't remember
I do.
the substance of those conversations.
Right, I definitely recognize her name.
And then I have one more name, and that's Felicia Hubbard, Hubbard. Does that
I may have
sound?
talked to her. Yeah, I think she was a prior girlfriend, but I'm not positive.
I'm just taking a look at my notes real quick. Do you remember, did you reach out to, did you reach out to any of the, friends, were there people that Mr. Harris recommended that you reach out to? Did you do any kind of investigation in that sense?
I think the only one that he had asked me to communicate with was Lena. That's the only family member. I feel like I communicated maybe with his parents by email. I do remember there was someone out of state that I communicated. It was either by letter or email or something like that.
And what would you have done? No, scratch that. What was your impression of Mr. Harris's statements to the police? I know he gave a couple.
I focused a lot on that. I mean, that was really the crux of my appeal and my issues in the case. At least, from my memory, that was a big issue because I was concerned that there was a misunderstanding. And that happens a lot. It happens when you've got someone who speaks a different language, maybe a different dialect. Are their statements being 100% translated? So that was a question, and that was a big issue at trial. The difference in statements, and that was one of the things that the state always likes to use. If you give different statements, then you're lying. And so I was looking to see if there was an alternative for lying. That maybe it was misunderstood. I remember I did look up. They had a translator. I did do investigations on the translator. I know I looked up. I think we had standard operating procedures, and then there was something with the Disabilities Act I looked up about whether or not Cobb County followed the protocols that they were supposed to. And I feel like the interpreter was not certified. I think it was like a professor or something at a local school. It was something where it wasn't certified, but it ended up not being something that, when I researched it, there was an issue, but wasn't a critical issue. And that's the problem on appeal. I'm dealing with harmless error. So my analysis on appeal is different than it is when I'm doing a trial. It's a very different analysis, and it's because of the harmless error standard.
Is there anything that you think could have helped you in that investigation as you're kind of researching protocols, that kind of thing?
Just an objection as to speculation, anything that could have helped, vague, speculative.
I'll rephrase that.
So, is there, as you were doing your investigation, did you consider, you mentioned that you did some research about the protocols. What were you sort of looking for there maybe that's where it would start.
Yeah, so I was looking to make sure that the police followed the rules, basically. And if there was something that, some angle I could attack the statements, some angle I could say that Tom should have argued that, some statement wasn't admissible because they violated some protocol or something like that. So that was an angle of attack. And I look at a lot of different issues, and unfortunately, a lot of them don't end up coming to fruition. So like I was explaining earlier about when I do the transcript, I do the same thing with issues. Like I'll do open records requests or, try and find standard operating procedures. And I do remember doing that here on the sign language issue. And then I'll review those and see if any of them are going to be big enough or good enough to win on appeal. And if they are, then I'll pursue them. And if I can't find anything that really helps or gives it teeth, then maybe that's an issue that I won't pursue.
And you had said earlier, you've had a deaf client in the past, but it was still like, you're aware that you're unfamiliar, and I'm.
Yes, I am definitely unfamiliar. The fact of having a deaf client in the past did not give me any expertise whatsoever. It's just happened, and I wanted to make sure I mentioned it, but it did not help me at all in knowing how to deal with this.
And so how would you characterize your defense as you were sort of putting this case together? What was sort of the theme that you were looking for?
Well, it's different on appeal than it is for trial. And one of the things I always look at is what was the trial attorney's theme to see if it was reasonable. But as long as they did their job, I mean, that's not one of the avenues that we usually win on appeal, because there's great latitude for them to pick whatever theme they really wanted to pick, as long as it wasn't completely patently unreasonable. So I reviewed everything, reviewed all the transcripts. I know that one of the main pieces of evidence against him that the state argued was this, these inconsistent statements. So I did investigate those, and I did look at those. And I can't remember that. I know you asked me about the similars. I remember them being in the file. I'm not sure who all testified to them, so I can't recall exactly who testified and which similars came in. I know the state was trying to get similars in. I think there was some testimony about it, but it's just been too long. I don't remember specifically who testified about that.
Okay, it was a long time ago.
It's been a long time. I learned.
Completely understand. Did you, so I'm gonna kind of shift gears a little bit and talk about some of the stuff that was in the discovery, which it sounds like you were able to review as part of Tom Ford's file. And one of the things we had talked about earlier was there was a GBI report about the bead.
Yes.
Do you remember that?
I remember that. And there, it's one of those things, there are certain facts that you always remember. I remember that fact.
So what is it that you remember?
I remember it being a very, very, very bad fact, because I remember some testimony about the bead being so embedded in her, and just being one of those things that sounded, I know a jury would have a hard time getting over. As soon as the jury hears something about someone taking a blow so hard that a bead literally is like, I think it was like almost embedded in her skull or something. It was a really bad fact that I'm sure this jury had a really hard time getting over. I know that, and I think my memory is from you and I speaking about the bead maybe didn't match his bracelet. I remember looking at the discovery and there being like him having, some type of jewelry like that. I don't remember seeing anything before I talked to you about the bead not matching them.
Do you remember GBI reports about the bead and DNA testing?
I don't remember DNA testing about the bead. I remember DNA testing about other things. But the bead, I just remember like how far it was.
Okay.
Where it was. So I think it was more the ME.
Okay. And then kind of speaking of the ME, did you review the autopsy report?
Mm-hmm. Yes, I did.
And are you familiar with Dr. Frist, Brian Frist?
Yes.
And were you aware of how he ultimately left office.
Yes, it wasn't, I don't believe it was under good terms. But I think it was after he testified in this case.
Say that again, please. What was that last sentence?
I'm sorry.
Something about the doctor, what was the last sentence?
He, Judge wanted you to repeat that last sentence.
Oh, he did not leave on good terms. And I'm sorry, it was around the same time that another medical examiner, I think at GBI, there were a couple that got in trouble for some things. And I don't want to say that Dr. First did what the other guy did. But there were a couple that left on some unfavorable terms. I'll put it that way at the time. But I knew about that. And I don't remember that being an issue in this case because I'm not, maybe it was the timing, maybe he testified and then my case was already past the motion for a trial stage when the doctor got his trouble. Not really sure. I mean, I would have used that. If that had benefited us in any way, I would have used that. So if he got in trouble while my amended motion for a trial was pending and he had not been in trouble when he testified during trial, 100% I would have used that.
And I think just I think I've already asked that question, so I don't think I have any other questions. Thank you.
Your Honor, may I?
Yes, sir. Yes, sir.
Good afternoon, Ms. Merchant.
How are you?
Just fine. How about you?
Good, thank you.
Very good, very good. Licensed to practice law in the state of Georgia since 2004. Does that sound about right?
That is about right. That is exactly right.
Licensed anywhere else?
No,
So it's been Georgia the whole time.
Georgia the whole time, although I did go to Florida.
We won't hold that against you for now. Since that time, you've been doing primarily criminal defense, private practice. Is that right?
Yes, it is. Primarily private practice. At the beginning, I was all public defense, but then since I left the public defender, it's been all private practice. And I really don't do any criminal, any civil. I'll carry my husband's bags, his depositions, and send it to trial him, but I don't touch this.
And when did you leave the public defender's office?
I left the PD's office in 2008. When I first got to Georgia, I was at the Southern Center for Human Rights, and then I went to the public defender's office. And when I left the public defender's office, it was 2008, and I entered private practice in Cobb County, and I've been here ever since.
And you do both trials and appeals, is that right?
I do. Yes, that's correct.
What's your balance? What's your percentage if you ballpark it, trials versus appeals?
It's about 50-50. It ebbs and flows. It's interesting. COVID obviously changed that. So, we didn't have a lot of trials for a while, and then when COVID ended, we had a lot of trials, so I had a lot of appeals. But I would say the average is about 50.
And at the time you represented Mr. Harris, approximately ballpark best guess, how many criminal appeals had you handled? I know putting you on the spot for a number, it's a horrible thing to do, but.
Probably over 100, and at the time I represented him, I was doing primarily criminal appeals. It ebbed and flowed somewhat with COVID, but it also ebbed and flowed with my children's age. And at the time that I represented him, I was stepping away somewhat from trial work because of the uncertainty and the hours with trial, so I was doing more appellate work when I represented him. But probably between the Court of Appeals, the Supreme Court, the 11th Circuit, over 100.
And in all those cases and all those appeals you handled, were the supermajority serious violent felonies?
Yes. I did. I have done a series of DUI appeals from a DUI lawyer in Atlanta, but other than that, it was all serious felonies.
And if that's appeals, then what about trials dealing with serious violent felonies? What about murder trials in specific?
Oh, that's the majority of my cases. The majority of my cases are murder cases and sex offenses.
Okay. And if you could ballpark at the time you represented Mr. Harris, approximately how many murder cases from any kind of disposition have you handled?
I mean, I was death penalty qualified, so that was the last time I qualified all of that stuff. I had a death penalty case in 2010, I think. Which was 2010, 2011, something like that. And so I had to put all that stuff on the record. And at that time, I know I was death penalty qualified, and I've tried a number since then.
Fair enough. Nothing think you indicated that, actually, if the record showed that you filed a skeletal motion for new trial, would that make sense? Would that sound right? That you filed the actual skeletal motion for new trial? Does that sound right?
That does, yes, and so, we've got that 30-day timeline, so I would always file that and then, amend it once we get the transcripts, whenever that happens.
And you touched on this a little bit during direct, but with Mr. Harris being deaf, your communication was both via a translator at the prison, is that right?
It was, I believe, the relay system, so I don't know where that translator was. I recall, he would set it up and I would have like a phone call where we had, I think it's called the relay system, but they would have some type of a translator. So I'm not sure if they were on video or how it was, but I would essentially be talking to a woman and he would be on the other side.
So there was that intermediary in your conversations, is that right?
Yes, there was.
Now, there was also interaction with you and Mr. Harris via email, is that right?
Yes, he did. He actually, I'm glad you mentioned that. He was unique because he did have email, where a lot of my clients didn't, but he had email, which was kind of nice. So yes, we did. We were able to email, and I would always write letters.
So did he write letters back? Did you correspond in writing, not just emails?
Email. I don't remember if he ever corresponded in actual writing. If he did, he had someone else writing for him.
But he would email you, is that right?
Definitely email, yes. And he would have to formally email, so I'm guessing he talked to them on the relay system.
So did he email you a lot? Was there a lot of back and forth there? How would you characterize the quantity, the volume of the emails?
It was unique because I didn't have clients in prison that emailed other than him, so it seemed like a lot. I don't know that it was a lot, but it was memorable because it was kind of nice being able to have that form of communication.
Now, in that communication, in that electronic, unique communication, did he have the ability to advise you of things he wanted you to consider raising at the motion for new trial stage?
Oh, yes, very much so.
And what kinds of things did he let you know he wanted you to look into?
I don't remember specifically anything that he raised, just for him, but that's common, that I field a lot of questions about things, and that's typical. That's just part of the job. A lot of questions, making sure that everything is done right. There was nothing that really stood out to me there.
So, did he ever advise you or let you know or suggest witnesses who he would like called at the motion for new trial stage?
He may have, nothing that stands out to me, but he may have.
And
if it was something, I would have talked to them. That's the thing. Like if he had a witness and they wanted to call me or I wanted to talk to them, I would have talked to them. I have no problem doing that, so I would have definitely done that.
So that's your standard practice. If you get a name from a client that I want you to run down this possible lead, it's your practice to call that potential witness and develop that to the extent you can?
As long as I have a phone number or some type of communication, email, phone number, something to reach out to them, yes.
Now, you testified a little bit on direct about remembering to have some manner of interaction with Felicia Hubbard. Is that right?
The name, it sounds somewhat familiar, but I can't really recall the extent of the conversation. It was more that Lena and Crystal were the two that I remember speaking.
Okay, so you spoke with his girlfriend and his sister. Is that right?
Yes, those are the only two I really remember.
And you had, were they in-person conversations? Were they in writing? Were they email? You just had some manner of communication.
I don't believe I ever spoke with them in person except for maybe if they came to court. They never came to my office. I never had any meeting with them. If I did see them in person, it was only in court. I know that they would have emailed me and then phone calls and things like that. Definitely not in person.
Okay. And if, just like with Mr. Harris letting you know about prospective witnesses, if they had let you know about someone who could have had some bearing, who might have been possibly worth presenting at trial, who wasn't, would you have also run down those leads?
If they had contact information, I would definitely talk to them. Or if they called me, I would talk to them, without a doubt.
So in your career, in your trial work and your appellate work, you've had no shortage in the way of occasions to employ experts. Is that fair to say?
Yes.
In fact, you've had recent pointed experience about seeking experts in cases. Is that fair to say?
Yes, I have.
The Ryan Duke case kind of sticks out about, yes? Mm-hmm.
And Cobb is really good about that. Cobb is one of those jurisdictions that's really good. They're not part of the public defender system. Ryan Duke, that was really difficult because it was part of GPC. Couldn't be more different than Cobb County.
But you're abundantly familiar with the process of obtaining experts, yes?
Yes,
And
definitely.
I'm certain in your career as an appellate litigator, you had occasion to raise trial counsel claims for not obtaining an expert.
Oh,
Is
I
that?
have, definitely. Oh, I've done that a lot, yes.
And you did not raise a claim in this instance about Mr. Ford not obtaining an expert, is that right?
I did not, no.
Did anything based on your research of the case reveal that it would have been worthwhile for him to have obtained an expert?
No, if I had seen that, I would have raised it. You know, I would have found somebody. You know, there's always an expert out there.
To that end, you reviewed the clerk's record, is that right?
Yes, I always pull the clerk. So part of my practice is always my paralegal does it. She pulls all of the pretrial motions, the pleadings, makes sure we have the pretrial transcripts from those, but we always get all of the orders, pretrial orders, because trial counsel is really bad at keeping records of those in their trial files.
Right, so you reviewed every piece of documentary evidence that existed in this case. Is that fair to say that was available to you?
Yes,
And had at least one, if not multiple, conversations with Mr. Ford? Is that right?
I did, yes.
And had significant email correspondence with Mr. Harris? Is that right?
Yes, we talked on the phone.
And I'm sorry to interrupt. And then, did you speak? I think you mentioned maybe, but did you speak at all or have any kind of correspondence with Mr. Harris's mother in this case?
Yes, I did. And I know that they have reached out. I did not talk to them extensively, but I know that we communicated at least once.
Okay. In all the interactions you had with petitioners, friends, family members, trial, everybody associated with this case, did anyone ever say, Mr. Harris didn't understand what was going on, that Mr. Harris did not understand the translation there was a question about whether he understood anything at the trial of this case?
No, not at the trial, no.
I know you indicated, and you raised on appeal, issues with the translation of Miss Bell, who I guess they found to translate his first interview. You raised issues with it? Yes. So you reviewed the entirety of the record with an eye toward reviewable issues with the translation. Is that right?
Yes, I did.
So did you also review potential issues to raise with the translation as it existed at trial?
I don't remember there being any issues with it at trial, any allegations, and that wasn't something that was really used against him. You know, the pretrial statements were different because those were used against him. You know, the different statements and what he said, and if it conflicted, that was used against him. So that was something that I could use around harmless error. You know, that's one of the things that with harmless error, like maybe some of the translations were wrong, but he didn't testify, so it wasn't really something that I could raise as a ground.
And did he ever let you know in your emailing back and forth, or did anyone let you know on his behalf that the translation at trial, he didn't understand the translation at trial? Was that ever communicated to you?
I don't remember that, but I don't know how he would know that. Anyway.
At the motion for new trial hearing itself, you waived Mr. Harris's presence. Do you remember that?
Yes. I waived his presence and I talked to him about that. That was his decision.
So you had email back and forth about him not being present there, right?
We did. I think we actually had a phone call about it too.
He advised you that he didn't want to attend. That was his decision. Is that right?
Their decision. He did not want to, and I believe it was because, at the jail we couldn't communicate. I mean, they did not have this. It's so much easier to communicate with a client in prison than it is a local jail.
Okay. So
I know that sounds great.
but after your review of the case, the grounds you were raising at the motion for new trial did not require his testimony. Is that right?
That's correct.
And you did not call any other witnesses at the motion for new trial other than Mr. Ford. Is that right?
Yes.
And this is, I guess, as you intimated before, this is because you didn't find or weren't informed of any other witnesses whose testimony would have been of any value at the motion of your trial. Is that right?
Right, that's correct.
And ultimately, on appeal, you raised issues with the admissibility of petitioner's statements. Is that right?
With this, I'm sorry, you kind of cut out for a second.
I'm sorry. You raised two claims on appeal, one with the admissibility of his statements, right?
Yes,
And the other based on Mr. Ford, I guess for lack of a better term, not being able to stop his client from giving a statement. Is that right?
yes, that was a big issue.
And at the time you raised those two claims on appeal, were those, in your opinion, the most viable, the most meritorious?
Definitely.
No further questions subject to potential recross, Your Honor.
Yes, ma'am, anything further?
I do. Sorry, can't read my own writing. So you had mentioned when you were talking to Mr. Oldham just now, how Cobb County is really good about getting experts, and that you've had to raise these types of claims about trial counsel failing to get an expert in the past.
Yes, it's a different process in Cobb than it is the rest of the state.
Can you describe that process a little bit?
Sure. No, I'm happy to. I know it all too well. So we have a system, a public defender system, where there's several counties that are opt-out counties. Cobb is one of those. Because of that, they have a circuit public defender, but it's controlled at the county level. So when you need funds for an expert, it's not like the rest of the state where you have to go to the council to get funds. You actually go and you get the circuit defender to sign off on your motion, and then you take your motion to the judge. And if the circuit defender has signed off, then the judge grants you the funds, and then it actually comes out of the circuit defender's budget.
So it's safe to say it's fairly streamlined.
It's very streamlined, yes.
And I know you had also mentioned, you really took a close review of the record, but it sounds like you also do some additional outside investigation, right?
I mean, I always look at the clerk's file, and then if there's something, if there's something that needed to be investigated that trial counsel didn't investigate, I can investigate that as well. If there's an issue like that, sometimes there is, sometimes there isn't. Sometimes it's it just depends on the facts of the case. But that's definitely something that I do if I need to.
And in a situation like this where you are a little bit less familiar with the interpreters and the language, trying to figure out how to ask that. As you're sort of like processing that, what kind of information could assist you?
Anything like just for example, you had mentioned something about the prior act evidence, the women. If one of them had testified and there was something significant, they had recanted, just to say, something like that, and I was able to investigate and find that, that's something that I would look up and I would try to work, try to allege, try to bring up. Sometimes there's a witness that wasn't interviewed, another witness at the scene that maybe wasn't interviewed, and so we need to go do that. We need to obtain records. I mean, I had one case where I didn't have, I was challenging the stop, and I went and I got all of the other officers' stops from that area, and was able to show that it was a pattern, it was a racial pattern, one on appeal for that reason. So, I can definitely go and investigate and get other information if I need it to establish a record.
When you're doing that in your cases generally, do you reach out to, for example, professors or people with expertise in different fields?
I don't usually reach out to professors. It would just depend on what the issue is. I don't usually reach out to folks like that. I mean, sometimes if I know another lawyer who has had a similar case, I'll reach out to them and say, how do you get that information? you know, I'm usually the one that people call to ask that nowadays. Like I spend a lot of time doing that. But no, I just, you know, I was a public defender for 5 years. I figured out how to get a lot of information from that, just by having to do it myself. So usually I will do it myself.
I guess, I mean, not just like law professors, but like if you're like trying to develop a claim, you know, is there kind of like a stable of people that you tend to go to or that kind of thing?
So I actually go to other people that are in the community that are good lawyers usually. I mean, that's usually what I'll do. And we talk about issues all the time. You know, other lawyers, and that's one of the things I miss about being in the public defender's office. But I use the Georgia Association of Criminal Defense Lawyers. We have a listserv, so I regularly will ask stuff on that. You know, or talk to people at seminars about it, things like that. You know, if there's a topic, I'll talk to someone and maybe they spoke on the topic. So instead of a professor, I guess along those same lines, like if maybe someone has spoken at a CLE on how to get juvenile court records, and I really need juvenile court records, I might reach out to them and say, hey, can you walk me through this?
So if you have sort of a stumbling block, you would typically reach out in some manner for outside.
Definitely, yes. And we have a lot of resources to us, and you know, and we have a great criminal defense bar in the state that helps each other.
You mentioned during like that you had a fair amount of email communication, and that this case was a little bit unique. But then you also, and I just wasn't sure if I had heard this correctly. Did you say that you were fairly certain that Mr. Harris would have had somebody else write that email?
And that's, you know, not the email. No, I actually said that about the letter. He wrote a letter. That's
Okay.
A lot of times letters are written by someone else. It's just my. There's usually someone in the pod that has really good handwriting, and they end up writing on the letters. It's just how it goes. So I never 100% believe that my client actually put the pen and wrote the letter. You know, it's their mind, but they may not have actually written the letter. That's what I was indicating.
Okay.
Not that I used to believe that everyone else was talking.
Okay.
You get a lot of letters that match penmanship.
We shouldn't do handwriting analysis. I got it. Let's see. And you had mentioned you remember talking with Lana, Mr. Harris's sister, and with Crystal. But these conversations, you don't remember them being in person. Is that correct?
I mean, I don't remember them informing my strategy, I guess is the best way to say it.
Okay.
You know, those are the things that I remember. Like, I remember things that inform my strategy or changed my strategy, or that I weighed them as being a witness. And I have a law partner, so my husband's my law partner, and he's really good at appellate stuff too, so I will always talk to him about it. And, you know, he regularly reviews transcripts and issues with me, and so we'll talk about that. So, I mean, if it had been something that was substantial, that I was like, oh my gosh, we have to find this witness, we have to talk to this witness, I would have talked to people about that. I would have pursued that. That I would remember. The fact that I don't really remember any of the conversations tells me they were more routine type conversations, you know, things like that.
And then I think I just have two other questions, I think. You had mentioned you had multiple conversations with Tom Ford. So when you're talking with Tom and he's describing this case, did you feel that the two of you were having similar experience, or were you?
With Mr. Harris?
Yes.
And the family?
Yeah.
Yes, we did. We had similar experiences. I mean, I think his level of patience is a little bit of mine, but.
I'm sorry, the interpreter was distracted by sound. Can you ask the witness to repeat that last sentence?
Sorry. Can you just repeat the very last thing that you just said?
Of course. I think Mr. Ford's patience level is a little bit different than mine.
And then last, I think you had indicated that you communicated with Mr. Harris's mom would you say that you had like extensive communication with her, or,
No, so that would be something that was different. I know Mr. Ford had much more extensive conversations. I did not. And I think that might have impeded their relationship somewhat. I think that Mr. Harris's family was somewhat demanding on Mr. Ford. They did not. I did not have that same type of relationship that he may have described. Because I know he and I talked about that. So he may have said stuff on the stand. His relationship with the family was way different than my relationship.
I think that that's all that I have.
All right, thank you. Anything further?
Ms. Merchant, you referenced on redirect about the process for obtaining experts in the Cobb County Judicial Circuit.
Yes.
By essentially obtaining it from the circuit defender. Is there funds from the circuit defender? Is that right?
Yeah. So what we would do is we'd have to file a motion, and we would do ex parte, and then what most judges did was they had, at the time it was Randy Harris, and he would just sign, like we would put a place at the bottom for him to sign that he had approved, our motion, and that was just sort of their gatekeeping, really. But I mean, he's gonna approve them, and then as soon as you got that, the judge said, whatever you need.
And this is through
I'm sorry, the interpreter missed that last sentence dropped off. Can you repeat the end of that last sentence?
You need me to repeat the last thing? I said, and then the judge would pretty much give you whatever you need.
And this is to the circuit defender, correct?
Yes, it's a circuit defender, so there's not public defenders. I don't know why they use these terms, but the circuit defender is a county employee who appoints cases out. So they appoint you, essentially be a public defender, but you're being paid out. So it's different than the public defender agency that actually has staff.
But it's nonetheless, these are for appointed cases, is that right?
Yes.
These are not for retained cases, right?
They will actually do it for retained cases too. I have had retained cases where they have appointed experts.
Is that unusual?
Not in Cobb County. It is elsewhere.
I think that'll be right.
Sorry, Your Honor, I have just one question. Sorry.
Okay, you just get one.
I'll be very short. I just have one more name to run past you. And my question is whether you heard this name from either Mr. Harris or from his family. So did you ever get a referral to talk with somebody named Anna McDuffie?
Anna, what was her last name?
McDuffie, McDuffie.
It doesn't ring a bell, but I'm happy to look and let you all know if I find anything. I'm happy to, any emails that I find I can share with you.
Okay, all right, thank you, that was it.
Thank you. All right. Okay, then the main witness be excused.
For response, yes, Your Honor.
All right.
Yes, sir.
All right. Thank you, Ms. Merchant.
Great.
Bye-bye.
Thank you so much. Good to see everyone. Take care.
I don't know if you want to take a, well, okay, she just, yours wrong. Flip the computer down or flip it in. Okay.
Okay, got another witness this afternoon?
So, petitioner has two more witnesses. I wasn't sure that we would get that far this afternoon, and they're the two that were actually sequestered. So we would need to take a quick break so I can call them back, or I don't know if they're outside or if they've gone home.
So you were planning to take them in the morning?
Yes, yeah. I was planning to take them in the morning, but I can see if they were available. But this,
If you're gonna have them in the morning, let's just wait till tomorrow.
okay.
Let's just do them. Is that all right?
That's fine.
I don't plan on being here tomorrow anyway, so.
And Your Honor, for the court's information, we have one witness tomorrow. She has limited availability between approximately 11 and 2, but I think we'll probably be able to reach her at that point, hopefully.
That's when she's available from 11.
Yes, she is kind enough to wait us in. She has interpreting responsibilities in other circuits.
Okay, I'll, we'll work that, make that happen.
Thank you so much, Your Honor.
Okay, thank y'all very much. We will see you in the morning. 9:30. Y'all traveling, back, 9:30, give you enough time to get here? Everybody? Okay.
All right. Your Honor, for the court's information, the scheduling order does have 10:30 on it, just to make sure that we can get Mr.
Don't pay
Harris.
attention to schedule at all. Not after the truck. No, we're gonna, whatever's convenient for us is what we're gonna do now. I'll, you know, if you work around that, that forms your window of opportunity, then we'll stick with what we had.
I was simply saying that how it informs corrections responsibility to produce the inmate at a specific time. Because the scheduling order is also a production order, it's the one that commands corrections to produce the inmate. We're specific
About
with it.
that. Let me see. Who we talk to? That's somebody.
Yeah. Lieutenant Grant.
Lieutenant Grant, okay, we'll try to get him here by 9:30.
We can certainly be here at that time, Your Honor, that's not a problem.
Okay, real good.
Thank you, Your Honor.
Thank you much.
All rise.
Are they housing him in jail here or taking him back out to jail?
No, he's coming from Georgia Central, so I believe he's going back and forth. Is that right?
He's a Central State, Your Honor.
He's with us, sir. We can have him back by 9:30.
Okay.
Yes, sir.
great. Thank you.
No, she's in Your Honor. We went back, it doesn't mean she's not, but it's a good point, she did.
Yeah, that's all.
Did they are mutually exclusive? Very good question.